Yes.
Yes, madam.
Fresh matter. What the urgency?
Is there because of the order of the honorable single judge that he is not paying the amount and huge public money is blocked. So that has been challenged before this honorable court. So that is
Which year?
26.
2020.
25. Sorry.
2025. Week after next.
Next week, anytime.
Next week we have difficulty.
From
Week after next.
Mobilize me.
It's a case matter, my lord. There is eviction matter was London signatures order against challenge, my lord. And that was stay order, my lord. That is your agency.
Eviction matter is stayed.
From my lord. There was also in this writ petition, my lord. Stay over there till the end, till end of the case.
Now writ petition is dismissed.
My lord.
And you have made the appeal.
Writ application has been disposed of and the ground that I shall approach. That is something different, my lord. There was stay matter. I have been evicted from a sub, my lord. That is
Next week we take.
my lord. Much appreciated.
From day 3. Where you can accommodate.
It's just
Much appreciated.
2 weeks or 2.
memo first.
Loading of the calendar. Then you have to decide. Yes.
State appeal case matter.
Any
I
urgency?
prefer because content proceeding is going on and it is fixed to next week, my lord.
Next week.
Next week,
Next week.
I have given the copy also.
Yes. You stay all right. Yes. Item 1. We are upholding your contentions.
Yes.
And we have allowed the writ appeal, dismissing the writ petitions. Okay? In the above circumstances, these appeals succeed. The interim judgments dated 20 September 2025 and 26 September 2025 of the learned single judge are set aside. Respondents' aforementioned writ petitions are dismissed, costs having been made easy. This we have referred to
Development.
various literature, jurisprudence, several judgments of the Apex Code, and
Rules of business.
resolutions of the United Nations on bribery, corruption, fair administration, etc. But we expected higher level of performance from your side. We were not happy. All research we have done. Where is the research from the government advocate? Absolutely no research. Item 2.
If I may please your lordships, my lord. May I please, my lords?
Yes.
My lord, the petitioner is aggrieved by the order of the honorable single judge, which is there at Annexure 1.
What was the order?
My lord,
Why
Annexure.
were you before the learned single judge?
Sorry, your lordship.
Why were you before the learned single judge?
My lord, I was challenging the orders of the estate officer, wherein eviction had been ordered, so also the demolition of my premises.
Demolition of your premises.
Yes, of which I was an unauthorized occupation of.
Then it is not
Under-
your premises.
Indeed, your lordship. Your lordship will kindly indulge me for one moment in Annexure 2.
You admit that the premises belong to the state.
Yes, yes.
You admit that.
Yes.
On what basis you want
Yes.
that premises to be given to you?
Please have Annexure 2, your lordship.
And is that true?
My lord.
Another WPC.
Yes, my lord, it is another WPC.
What is this?
My lord, it is 314 of 2016. My lord would see a series of petitioners. The present petitioner's name, find placer, serial number 73. That is, lordship will see.
What it said, judgment said?
My lord, relevant part, page 38.
38.
38, your lordship.
Ah.
My lord,
Heard.
having heard learned counsel for the petitioner, Mr. Behra, learned ASC for the state, and learned counsel appearing for the opposite party, number 3. Instant writ petition.
Para 7.
Para 1.
Para 7, na?
This is the order dated?
17/11/2023.
2023.
This is another writ application.
Yes,
Page
another
30,
writ.
page 38. 38.
Yes, the same writ that I was referring to in Annexure 2 of the writ appeal. My lords have writ appeal, my lord. Yes, writ appeal, Annexure 2, my lord.
WPC.
Yes.
Writ appeal is
It applies 2033. It said single bench order has been annexed.
No,
But page
the order
38.
that is something 1123.
Yes, my lord, I'm coming to the relevance, your lordship, for 2 minutes, your lordship. The petitioner, along with 112 other petitioners, had filed another writ application for a reason which your lordships will see at page number 38.
38.
Yes, my lords.
Huh.
Heard, learned counsel for the petitioners, Mr. Behra, learned ASC for the
Okay, next, go to next para.
My lord, may kindly
It's over. Next.
directly come to paragraph 4. In fact, according to the learned counsel for the petitioners, evictions and demolition was declared by the opposite party number 3, opposite parties, and in particular, namely opposite party number 3, without considering the government's decision wide annexure 5. In other words, the contention is that before any such impugned action, which is either contemplated or so declared by the opposite parties, and particularly opposite party number 3, the policy of the government by a resolution dated 14th August 2015 of the Housing and Urban Development Department should have been scrupulously followed. The submission of Mr. Behra, learned ASC for the state is noted down. The action which was said to be contemplated stands justified by the learned counsel appearing for the opposite party number 3. 7. However, having regard to the submissions of the learned counsel of the respective parties and the aforesaid resolution as at annexure 5, which is with respect to the policy decision of the government under revised scheme for affordable urban housing in Odisha 2013 vis-a-vis slum dwellers, the court is of the considered view that if any such decision is taken, unless the matter has become infructuous, it shall be in consonance thereto.
Correct. What is that?
My lord, the policy of the state government.
Why it was not part of the proceedings?
My lord-
of the learned single judge. We will not look into it.
My lord, learned single judge, this order was there.
All right.
This order was there before the learned single judge.
This policy decision.
The policy that has been referred to in the policy that has been referred to at paragraph 7, that, my lord, is this.
No, unless it is part of the record,
Yes.
we will not look into it.
My lords.
Go to other point.
Yes. So, my lords, this policy categorically stipulates.
Where is that policy? It's not part of the record. We will not look into it. There is a provision, Order 41, Rule 2526 of CPC, which is made applicable to writ proceedings. You have
Yes.
to make an application, seek leave, explaining why you could not produce before the.
That I bow down.
Then court will consider the application.
Bow down, your lordship. My lord, in another proceeding, what the petitioners had done, he had approached the Odisha Human Rights Commission, which is a part of record at annexure 7 of the writ petition. That order, your lordship, may kindly see. Annexure 7 to the writ petition, page 50, relevant page 51, last paragraph, taking note of the fact, my lords have it? Taking note of the fact that since the eviction proceeding is going on, adhering due process of law, this commission bereft of its jurisdiction to interfere with the matter. However, this commission closes this proceeding with a recommendation of the authority in GA and PG department to consider the case of the complainant for rehabilitation if he is entitled for the same. My lord, what I state is that, my lord, I may be rehabilitated under the state's policy. It is a mandatory discretion.
Where is the policy?
My lord, the policy has now been culminated into an act, your lordships.
It has become act only.
Sorry, my lords.
Has it become a statute now?
Yes, your lordships.
Statute.
The statute is the Odisha. Yes, the Odisha Land Rights to Slum Dwellers Act. It is the bill,
We
2017.
have a copy of that. Which section? Just read a section. Take that and read section, then give us.
My lords.
Give that. We have to read now.
Is it act to me? Slum Dwellers Act.
Read. We remember. Yes.
My lord, the definition clause, section 2.
Who is the slum dweller?
Yes, my lord. That definition, my lord, is R. Is slum or slum area means a compact settlement of at least 20 households with a collection of poorly built tenements mostly of temporary nature, crowded together, usually with inadequate sanitary and drinking facilities and unhygienic conditions, which may be on the state government land in an urban area. S. Slum dweller means any landless person in occupation within the limits of a slum area. Correct. My lords.
Where is that? Where have you paid this? This is a slum area, and your client is a slum dweller in the definition of this, and therefore he is entitled to protection.
My lord, my case before the learned single judge was that there is an order passed in terms of the state policy. I must
speak.
My lord, I'll just read you a lordship the paragraph.
Not part of the record. We'll not look into unless if you want, we'll give time to produce it. Is another thing. But without making it a part of the record, we cannot look into.
I bow down, your lordship.
Are you an income tax payer?
My lord, I have got electricity due. No, my lord, I'm not an income tax payer.
Income tax payer.
No, my lords. I'm a homeless person who is.
Do you fit into the definition of slum dweller? Have you structured your petition that way?
My lord, will kindly see my writ petition, my lord.
No, we are asking this question. Read that sentence. We need not look into it. What,
my lord, my writ petition,
etc.
My lord, my writ petition was structured in lines of the judgment, the order of the Honorable Single Judge in the previous writ petition of the year 2016.
We are asking.
Yes.
You are pressing into service the provisions of the Act.
Yes, my lord.
Therefore, we are asking you,
my lord,
whether you have structured your petition to attract the provisions of the Act.
My lord.
You should say, petitioner is a slum dweller.
My lord.
And he is residing in the slum area as defined under provisions of Section 2 of the Act. Therefore, he is entitled to protection. Where is that ever made?
My lord, paragraph 14 of my writ petition.
14.
My lord. Paragraph 12 also my lords can have. 12 and 14 lords.
For poor and landless person. No, that is not the definition. If they are evicted from the state government land, they would become helpless and shelterless. And that happens.
Para 14.
Right to shelter, which is an integral concept of rightful is guaranteed freedom has been infringed in the case of freedom by not providing any land to the petitioner and his family members to live under the Orissa Land Rights to Slum Dwellers Act in 2017.
My lords.
Very vague pleadings.
I bowed on my lord. That is there, but my lord, I've made an amendment to the effect that I have to be protected under the Slum Dwellers Act.
The protective provisions in the Act. Slum dweller, we have understood. Slum area, we have understood.
Land Rights, Chapter 2. Notwithstanding anything contained in any state law for the time being enforced and subject to the provisions of subsection 2, every landless person occupying land in a slum in any urban area by such date as may be notified by the state government shall be entitled for settlement of land and certificate of land right shall be issued in accordance with the provisions of this act. The land shall be settled in favor of a slum dweller to the extent specified herein under, namely a slum dweller shall be entitled to a land as nearly as may be 1, where the slum is situated within the municipal council area not exceeding 45 square meters.
Right. Where have you made the application?
Lord,
for grant of certificate under this act?
My lord, it is for the state to give me.
How state will know? Is there any application format, etc.? There must be. In your state statutes, state legislations are ill-drafted. It's one thing, but assuming, still we can make out some sense in that, because definition is slum dweller.
My lord.
And the protective provision uses the expression landless people. Person.
My lord.
Anyway, we'll assume that same meaning.
This eviction order is in OPP Act.
OPP Act, your lordship.
So, have you moved in appeal?
My lord, appeal has been dismissed. The appeal
by the district judge.
No, my lord would kindly see, my lord, annexure.
We are asking.
Appeal by the director.
My lord, appeal by the director.
For the director.
For the director.
All right.
But that has been rejected.
Against that, you have come in ring.
Yes, your lordship.
Did you take up that contention before the director? That I am entitled to protection under this the Slum Developers Protection, Developers Protection Act. This
My lord, that government I did not find in the disposal order, the impugned disposal order. My lord, because the case that I wanted to I presented was this, that I am entitled in terms of the orders of the writ of the year 2016, wherein there is a policy decision and the Honorable Single Judge had directed that before you displace me, you give me the opportunity of reallocation.
Were you not given an opportunity of hearing before making that order?
Yes, my lord, I was given an opportunity.
How long the case went on then?
My lord,
from the beginning, how many years?
My lord, 1.5 years.
1 year, then how much time should have been given to you?
No, my lord, my lord, first I was served with a notice in Form A under the OPP Act.
Correct.
That was on 8/1/2024.
8/1/24, more than a year.
Yes, Sir Lordship. To appear.
More than a year. 8/1/24, 8/1/25, 8/1/26, 2 years.
Yes, Your Lordship. My lord, I was in position since.
How much time you want now?
My lord, I'm only praying that I may be rehabilitated in terms of the act.
That's not possible. That's not possible.
My lord, there is an order of the Honorable Single Judge which stated that categorically
no. You consider your case, that's all.
Yes, please see that order once again, Your Lordship.
We have read that.
Yes,
Para 7 you read that?
Yes.
I can reproduce that order.
My lord, for my satisfaction, Your Lordship, can one against. However, having regard to the submissions of the learned counsel for the respective parties and the aforesaid resolution as at Annexure 5, which is with respect to the policy decision of the government under revised scheme for affordable housing in Odisha 2013, vis-a-vis rehabilitation of slum dwellers, the court is of the considered view that if any such action is taken, unless the matter has become infructuous, it shall be in consonance thereto.
Correct.
So, my lord, once there is an eviction that has to happen, in case such an order is to be passed, prior to passing of such an order, the petitioners have to be given that opportunity of rehabilitation as per the state's policy.
Where did you seek rehabilitation?
My lord?
Where did you seek rehabilitation?
My lord, in case they are wanting to seek eviction.
No.
Yes.
Eviction, they have taken proceedings.
Yes. So
you have said, I am applying under the Slum Dwellers Protection Act.
My lord.
Wait till a decision is taken by the competent authority.
My lord.
Where have you applied for? Government itself should find out who is the slum dweller and grant the protection.
My lord, this order has been communicated and there are contempt proceedings.
You see the order. What is the order? The appellant was asked to produce the documents in support of his claim, but on subsequent dates, the appellant simply appeared but failed to produce any document. The appellant has been given adequate opportunity to produce the relevant documents in support of his claim over the case land.
My lord, he
No
does not
response
have.
in this regard is received from the appellant.
Yes, my lord, he does not have any land. My lord, it is an admitted fact. I am in unauthorized occupation. I do not have anything, my lords. I do not have.
Then to everybody in the Cuttack market, you have to allow it. If he comes and says, I am a slum dweller,
my lord,
there should be a vouching material, minimum material.
Yes, my lord, electricity bills,
the sale deed, etc.
my lord, electricity bills and other things.
Why did you not produce it before the authority?
My lord, there is an inquiry to that effect. They have done the inquiry.
You
Please see that, my lords.
You are only wasting the time.
No, my lord, it was the state's counters.
It is a vacant land between two government quarters.
Correct, my lord. Correct, my lords. My lord, this land was allotted in 2022. I was residing there since 2013 onwards, and I had come before this honorable court in 2016 in a writ petition. I was residing, this land has been allotted at a subsequent state because she was a female and she feared that probably these people are creating nuisances. So she made a complaint. Please see, my lord, that complaint, which is a part of the record of the counter, that your lordship will see at page 62.
Heard.
My lords.
It's a government land.
My lords.
It's all government property. There is one famous statement by Hugo Precious, who's in his famous book, De Jure Belli Actasis, that belongs to none belongs to all. That belongs to all belongs to none.
My lords.
That is the principle. We have to protect the property. It is the duty of the Constitutional Court to protect the public property. Otherwise, these people will allot a hand to anybody. Whoever is a party worker, they will allot everything. We have seen such judgments here now.
My lords.
No.
My lord, may kindly grant me indulgence that some time may be given and I make a representation for rehabilitation.
No. If you say we'll give time, if you say you undertake to vacate, not otherwise. We are passing the order on merits. We see government property that cannot be laundered or distributed to the property by the officials of the government of the day because XYZ children. That is not the object of that.
My lord,
And you have not taken up any stand. You said you have been residing in that particular property. You did not produce a bus ticket sized document. Time was given to you. You did not. You means your client did not.
My lord.
Maybe whoever was appealing. Nothing. We have taken a lot of time now. This is intra-court appeal.
Due process of law has also been followed.
Yeah,
My lord, I bow down, my lord.
The act itself.
My lord, I'm only saying this with the utmost of respect, my lord. My lord, if your lordships can
Great
consider, my lord, with the
Because you argued very well. We'll write one sentence on that.
my lord,
Argue.
my lord, just one more judgment in case I can show to your lordships before your lordships decide.
Dismissed. Agreeing.
My lord,
Next meeting.
please protect me, my lord. Please protect me, my lord. I will undertake to vacate, my lord. My lord, I undertake to vacate your lordships. Please protect me, my lord. A reasonable time of 6 months, my lord. In case your lordships consider,
6 months.
my lords.
No.
Whatever
You
lordships
should
decide, my lord.
file an affidavit now saying that within 2 months you are vacating and you are giving up a right of appeal, challenge, further challenge also, not otherwise, because this is only at mercy level we are doing that. Ask your client, don't take risk without consulting your client.
May I pray for one day.
No, pass over, pass. Nothing like that. Yes.
Item 3.
Otherwise, treat it as dismissed. If you do not come within 5-10 minutes, treat it dismissed. Okay? No property will remain for the posterity. All people will occupy, and population is growing like anything. Where other children should go? Yes,
My lord,
next.
would we also be kindly sympathetic to the
No
slum
question of
dwellers, my lord?
sympathy in law.
Yes, my lord, because there is a law to that effect, my lord.
We have answered.
My lords.
We have answered.
My
Yes.
lords.
Item 3.
3.
In this matter, the petitioners have the
Yes. Yes, sister.
in this matter, the petitioners are the employees, canteen employees of the Paradip Hospital Limited lordships. They are working since more than 30 years lordships, and now they have challenged they have prayed for the regularization before this honorable court in 1996 lordship. That is the annexer 1 is the order lordships where the writ petition was dismissed, and the relevant parties at page 48 lordships.
Where is the impugned order?
Now, your lordships, I am before your lordships that that matter has been travelled to Honorable Apex Court, and where the Honorable Apex Court has been pleased to direct the matter. That is that order is at page 76 lordships. That needs to be implemented, your lordships. Page 76.
Oh, where is the impugned order of the learned single judge?
This is writ petition.
Writ petition.
This is
Detail
WPC.
number 3. WPC.
Well,
You are right.
The first time the petitions approached this honorable court was dismissed by the annexer 1, your lordship. That is that relevant parties for page 48. May I please?
in 1998,
Yes, lordships.
then it traveled to
That the para.
Supreme Court.
Yes, sir. The para 11. May I place that?
You should seek regularization at the hands of the principal employer.
Yes,
Kindly
lordship.
comes to para 11
No, your lordship.
of the
That,
judgment.
in that para, pursuant to that para 11, your lordships, the petition moved the Honorable Apex Court, and that was withdrawn because in the meantime, one notification was put forwarded by the state government, and that is at annexer
Itself
2.
it was withdrawn.
Yes, lordships. At page 49, because of the page 50 is the withdrawal order, your lordships. Page 50. 50. That
Dismissed as
SLP.
withdrawn.
Yes, lordship.
Then what?
Because of the notification at page 49, your lordships, where
But
that says, your lordships, because in exercise of the powers conferred by sub-rule 1 of rule 66 of the Orissa Factories Rules 1950, the state government do hereby appoint the 3rd March 2000 as the date on which the provisions of Rule 66 to 77 of the
Sub-rules.
sub-rules relating to the canteen shall come into force.
What
That is
66
PPL.
says?
Yes, Lordship. That 66 is
But the apex court judgment, does it say that?
after that, Your Lordship. No, Your Lordship, another day thereafter, what happened, Your Lordship? Again, after that, that is at page, Your Lordship, kindly have a glance at page, that is page, that is at page 54, Your Lordship. No,
What
page,
is that?
no, Your Lordship. Sorry, Your Lordship, that is at page,
OJC.
Your Lordship, that is another order. But pursuant to
This is between whom?
that
The order is
this in this that particular page 54 order is because of that again pursuant to the regularization of those employees petition workmen employed in the statutory canteen of Paradip Phosphate Limited, and in this order you will kindly have a glance at page 56 Lordships, where the appropriate government has been referred as the state government, Your Lordships. In the middle, it has been, therefore, it is admitted by first paragraph, Your Lordships. It is admitted at the bar that the appropriate government as defined in section 2(1)(a) of the Act would be the state government to prohibit employment contract labor, Your Lordships.
Yes.
Why I am taking Your Lordships to this judgment, Your Lordship, because after that, what happened, Your Lordships? They have issued another notification in 28/4/2000, Your Lordship. That is at Annexure 4, page 52.
what is the notification legal effect of that notification?
Yes, Lordship. That is at page 53, because they have page 53, Your Lordship. 52, it starts at page 52 and 53 is the relevant part where I am placing that
It
notification.
prohibits employment of contract labor.
Yes, first paragraph of the page 52, first paragraph where they have
They have been engaged in these places.
no, Your Lordship,
List of.
they have the schedule will or do hereby prohibit the employment of contract labor in the works.
Correct.
They have prohibited.
That what follows?
Yes, Lordship. In this notification, what they have done, only at page 53, only the specified part, the DAP plant cleaning and of granite dry section, only a specific section of the PPL employees. In that particular section, they have prohibited the contract labor system, Lordships. But so far as these petitioners are concerned, they are canteen employees, and they belong to the statutory canteen, which is admitted fact, Lordships. But they have not.
What is my question? Which provided under the Factories Act.
Yes, Lordships. But Rule 46, though they didn't extend these
This provision is not for
extended to this.
So they can you can
Continue to
engage
be-
it there.
Yes, Lordships. But after that, Lordships, again the petitioners approach this Honorable Court, and that
You are engaged by whom?
by the
contractor of
Contract labor.
no, Lordships. Fact remains that since 87, this is the first judgment, page 44, it was admitted that PPL is the when the canteen was established, there was no question of a contractor, Lordships.
Who had taken your services?
PPL, Lordships.
PPL.
Yes, Lordships.
PPL.
This is the institution. It was Government of India. It was, but now at Ajon date, it is privatized, Lordships.
Huh?
Ajon date, it is privatized.
When you
Ajon date.
became private agency hirer?
That is up 2002 up onwards, Lordships.
Since 2002, you are working under a contractor.
No, PPL was privatized, and I am still continuing under the PPL, Lordships.
on which government's share was
Yes, lordships. Yes, lordships.
And it has been privatized.
Yes, lordships.
It's a private entity now.
Now,
Not
assume
the
that-
Article 12 entity.
yes, article, it is not, it's not coming under the Article 12.
Then how writ petition is maintainable?
Obliged lordship. To that effect, your lordships, because in 2015 also that order what I was showing you lordships, that is at page, pursuant to that DAP canteen employees, they approached this honorable court after the privatization of this organization lordships. And this honorable court has been pleased to interfere in that matter, and they have been regularized, and that order has been implemented in 2015, your lordships, to those employees.
Now, how writ petition is maintainable?
That-
Under section 617 of the Companies Act. Perhaps it was a company earlier,
Yes, lordships.
government company.
Yes, lordships.
There is a corresponding provision in 2013 Act also.
Yes, lordships.
Under section 617 of the Companies Act, when it shall be deemed to be a government company is defined. The government company is defined under the erstwhile companies, section 617 of the Companies Act, which is now repealed. Can anybody company corporate side practitioners? Which is the section which defines government company? The corresponding provision to section 617. See, no. If it is not a government company, then it ceases to be an instrumentality of the state. Under the Apex Court decision in Raman Dayaram Shetty versus International Airport Authority, then no writ jurisdiction. Raman Dayaram, Somaprasad Rekhi, Sukhadev Singh versus Bhagat Ram, so many judgments are there. They go against you. How it is maintainable? The other judge granted relief is no answer because he did not consider that aspect of the matter. But unless it is an entity under Article 12 or it exercises statutory functions or contractual functions which have got abundant public law element. 86 Supreme Court. LIC of India versus Escorts Limited. Justice O. Chinnapareddy's judgment. Only then writ is maintainable, not otherwise.
See, 206, read and considered the grounds on which the claims of the workmen for regulation in the statutory limit have been dismissed to a satisfied that the said order department allowed to remain in the court. We accordingly interpret with said order and remit the matter to the state government for denouncing constitution and passing an appropriate orders which will go which
Perhaps in under ID Act, it is under ID Act. But even that does not reclaim the respondent as a state.
The appeals are allowed and it's a great wages.
Perhaps it was a reference under 1013 of the ID Act. Against that,
Against that,
they went and that is set aside.
and that is how.
245. Section 245 is equivalent to 617 of the old Act.
That is definition clause. Who within bracket 45.
That's
definition clause.
Now, that was definition was in the Companies Act under section 617. 17, 617, that's what. Now that has brought down to clause 45 of the Companies Act. Even under that, if the company holding is reduced to below 51%, then it ceases to be a state because pervasive control is not possible. The doctrine of pervasive control. Where is the control of the government over these things?
Only my limited prayer before you lordship that the order of Honorable Apex Court that is at page 76 lordships that has been may place that part relevant parties having read and considered the grounds on which the claims of the workmen for regularization in the statutory canteen has been dismissed. We are satisfied that the said order ought not
should not remain unforever.
and later on your lordship we accordingly
Which was that order?
that particular order is
Then how do we make sense of that?
That is what we read, right?
yes lordship,
That order we assume must be section 1013 order,
Under
where you had sought for reference and government did not refer it. That order
Yes.
appears to have been challenged before the Apex Court.
that particular order that is not available with the petitioner and I may be given 1 week time. I will apply the certified copy.
Argued at length.
One cannot be.
Come on.
immediate.
Counsel for the petitioner or the
I'll apply certified copy of the order from the court, your lordships.
1 week to come with more preparation.
Certified copy of the order I will apply from the court, your lordships.
2 weeks.
Obviously.
Yeah. How much time you have spent from only on this? Yes. Yeah. Come.
Item 4.
That's why for the
You come, just read Sukadev Singh versus Bhagat Ram. And no, thereafter also, thinking that Soma Prasad Rekhi versus Khalid Mujib Suravardi. This answers against you, where they have considered R.D. Shetty and they have travelled further. Yes.
Item 4.
Yes, sir.
I am for the opposite party, my lord. This order has already been upheld by this honorable court. The CAT order which is passed by
my lord, there is several cases your lordship
covered matter by him also this, sir.
The subject matter of this petition is substantially similar to the one in WPC number 353 of 1925, disposed of by a coordinate bench of this court, by the order dated, by this bench, by this bench, by this court, wide order dated 12/1/2026, wherein challenge to the offshoots, an order of the kind has been having been examined, has been negative. First time. Next one. In the above circumstances, on the principle of verity, this appeal also meets the same fate. First having been made easy. Is there any order for implementation?
implementation and one is the order of this
First time.
honorable
The impugned order of the CAT
25/8/2025
shall be implemented within a period of 8 weeks. 8 weeks. 8 weeks. Record from this date. This petition with the Union government seeks to call in question the Central Administrative Tribunal's order
25/8.
dated 25/8/2025, entered in respondent employees, opposite OP employees, OA number 260/00294 of 2024-22, whereby relief has been accorded wide paragraph 6,
No, 6.
which reads as under. See, hence the order modifying, withdrawing the granted to from here it is. Paragraph not entire. It begins with the order modifying stroke withdrawing the GP of rupees 5,400 granted to the applicant signs. So from there up to end of the paragraph. All right.
My name may be senior panel counsel replacement.
Maybe.
Item 5.
Yes.
Your Lordship, this is my second round. Initially, there was some defect in the prayer portion. The Lordship directed me to convert that, challenging the order of the learned ombudsman, which I following the second hit application has been filed. Initially, there was a defect in the prayer portion, Your Lordship, that I mentioned particularly.
You withdrew that writ petition
My Lord.
with liberty to file afresh.
Lordship.
Where is that order?
Order, I don't have.
Then how to, if you had already appeared before the court and you have withdrawn, unless you show liberty was accorded to you to litigate afresh under Order 23, Rule 1 of CPC, or in terms of that, you cannot maintain second petition.
Your Lordship, tomorrow I will take out the
Next
call.
one.
Item 6.
Get the request now.
Pray for an adjournment, my Lord.
2 weeks at the request now.
Item 7.
Can I pray for next week? Because some documents are required. I have missed out.
Item 8.
I am appearing on behalf of the conducting counsel. A possession notice was issued on 6th of February under SARFAESI Act. The petitioner is the,
Agree for mediation.
Your Lordship.
How can we direct mediation in the voluntary? Law gives you such power.
Your
Such a
Lordship,
right.
Your Lordship, we just want sympathy from this court.
Sympathy.
We don't have any merits on
It
this.
appears we have bought some rasgulla. Give it to my daughter.
We don't have
Sympathy.
merits.
We can't do that. Once if we do sympathy, other persons will be queue up here saying that you have given sympathy.
Your Lordship, the
Yes, then
petitioner,
you give it to YZ also. Where to go?
Your Lordship, the petitioner is ready and willing to pay,
You are
but
very ready. How much money you had taken?
17 lakhs.
17.
Yes.
That was in which year?
In the year 2022.
2022. Now, what is payable now?
Your Lordship, only.
Possession notice has been issued.
Your Lordship.
How much? This is issued on which day?
6th of February.
6th of February. How much money they are demanding from you now, presently?
20 lakhs 5,840.
Then you pay 1/3 of the money. You will stay this. You have to show bona fide.
Yes, Your Lordship.
And you have to change your prayer also. Anyway, you can make out that. It's a housing loan. Housing loan. Which loan?
Business loan, Your Lordship.
Housing loan.
Daughter, what is your name?
What is your name?
Samarpita Das.
Samapita Das.
Samarpita Das.
Samarpita Das.
Samarpita Das. Okay. Heard learned counsel Miss Samarpita, Miss
Miss Samarpita.
Miss Samarpita Das, who argued well. First off, she draws our attention to Annexure 3 possession notice issued by the OP Bank on 6/2/2025 and submits that our client is ready and willing to settle the outstanding loan if a reasonable period is granted. First off, she also agrees with the suggestion of this court to pay a reasonable amount to show bona fide. First off, she also tells that if the possession notice is not stayed, our client would be put to a manifest injustice and a great hardship. First time, a prima facie case is made out for issuance of emergent notice to the office and for grant of reprieve pendent lite. First one. Next one. In the above circumstances, the application in No, you have not filed any application.
No,
You have not filed any IA at all.
no.
Then how to protect? In the issue emergent notice, returnable immediately after service. First time. Hello. You argued well. You have argued well. Yeah. Take emergent notice.
Yes.
Yes.
Item 9.
Please, Your Lordship. My lord, petitioner before Your Lordship is a farmer. He has availed an agriculture cash credit loan of 29 lakhs, Your Lordship.
He's a farmer.
Yes, he's a farmer, Your Lordship. He had taken an agricultural cash credit loan of 29 lakhs, Your Lordship. He had repaid 8 lakhs, and on 1/5/2025, the loan account of the petitioner was declared as NPA, Your Lordship.
On
1/5/2025. It was
when the loan was taken.
in the year 2021, Your Lordship. That is
29 lakh.
29 lakhs, Your Lordship. Now
That's the sanction loan.
yes, Your Lordship. That is on 22/9/2021, Your Lordship. 22/9/2021. Yes, he had repaid 8 lakhs. Thereafter, on 1/5/2025, it was declared as NPA, Your Lordship.
LPA on
1/5/2025, Your Lordship.
1/5/25.
Yes, Your Lordship.
Ah.
Thereafter, Your Lordship, the petitioner immediately, by giving represented the authorities to take the loan account in the OTS scheme. So he's ready and willing to pay, to deduct the interest part, and as per the RBI guideline, to induct him in the OTS scheme, Your Lordship.
How much money now due?
As per Annexure 3, it is 33,30,462, Your Lordship.
You pay 12 lakh within 1 week. We will stay the coercive proceeding.
15 days, Your Lordship.
No interim application is filed. My brother is alerting me. He has not filed any interim application. Took emergent notice. You should lie as lawyers. You should know. Why are you sitting in the court? I'll tell me to judge how these judges operate. What human factors? What is the extent of human factors? What are the extent of jurisprudential values? What is the extent of beauty of presentation, language, etc. Is it done? Whether can he grant interim order in this or not?
I beg your pardon, Lordship.
We'll pass over, you go and bring the application.
Lordship.
All right? Let us see. Call it tomorrow? Yeah, Monday?
On Monday.
Monday. Get the request from you. Yes.
Item 10.
May I please? My lord, this is a housing loan. And
Housing loan of which year?
in the year 2021,
How much?
and that was first it was 20 lakhs, and thereafter in 2022 another 9 lakhs they have sanctioned. Total to 29 lakhs.
What your client is doing?
He's a housewife and his husband was only earning member. But he was suffered in a serious disease for which the loan was irregular. But till 12 December 25, she has reported some amount.
How much?
He has reported near about 50,000 something.
15,000.
50,000.
For 29 lakh, 50,000. Then how?
My lord,
Who are you?
I am appearing for opposite party.
Wait, we are
I have
asking.
entered in cabinet.
Therefore, we'll hear you.
Oh, yeah.
We'll hear you. How, unless you show some bona fide by making at least 25%, 30%.
My lord, I am ready to pay. I am ready to pay.
What is?
He is
So,
ready
my
to
lord,
pay.
if
That's
you
what- no.
that amount, he has deposited the irregular amount. If you deposit about 5 lakhs, the account will be upgraded.
My lord, I
Simple.
will deposit.
That is the
Within what period you are doing?
Within 30 days. Maximum.
Within 30 days.
Within
can
30
it be?
days.
It can be because you will have 31(3)
Yeah.
for account closing.
But immediately it may be directed.
No, that's how we do that. 30 days means 30 days spread over.
And
Within 1 week, he has to make some amount to
Yes,
go bona fide.
yes, my lord.
2 weeks, 50% amount it should be.
Right.
3rd week, 70%.
My
4th week, entire.
my lord.
Understand?
I'm
so, my lord, within a 1 week, he may be directed to deposit at least 1 lakh.
Yes.
my lord, I will deposit.
Yes. This is a challenge by the borrower in this petition is to the pursuit proceedings of recovery of loan initially sanctioned in the year in 2021 in a and in 2020 on 3/6/2021 and later which date later loan
Initially 20 lakh, then 9 lakh was on?
Well, on 4/6/2020, no, 15/4/2022.
15/4/2022. Totally in a sum of rupees 29 lakh for housing purpose. First one. Next one. Learned counsel appearing for the petitioner submits that the breadwinner of the family having contracted some disablement, the loan came to be certified as NPA, loan account came to be certified NPA, and that now the petitioner is ready and willing to settle the outstanding installments to make the loan account regular, if reasonable time is accorded to be first up. He also tells that the interest payable on the delayed payment will also be paid. First one. Next one. Learned senior panel counsel appearing for the respondent opposite OP Bank on KVF, having stoutly opposed the petition, now fairly agrees with the suggestion of this court that the loan account can be regularized if petitioner borrower makes payment of all outstanding installments with the interest that has accrued due thereon for the delay within a reasonable period. He tells us that it should be not beyond 4 weeks. First. Next one. Having heard the counsel for the parties and having perused the petition papers, more particularly keeping in view the fair stand taken by the lender agency, we are of the considered view that the proposal of the petitioner is fair and reasonable and therefore merits acceptance. First one. Next one. In the above circumstances, this petition is disposed of, permitting the petitioner to pay the entire outstanding installments with the due interest thereon as an interest thereon in 4 weekly equalized installments as an. Number 1, the first installment shall be remitted within 1 week, second in the week next following, third in the week following the same, and fourth in the last week. Failing which, it is open to the bank to take up coercive proceedings in accordance with law.
Amount may be mentioned.
No, how many installments remaining, we don't know. You are not stated. So say about 10 installments are there, 9 installments are there. Okay, then they should be distributed as a
accordingly
for equalized installments. That way to be. Next.
Item 11.
No costs.
Pardon. Lord, I've taken instructions. I'll file the affidavit. Lord, I've called the clients. The Lordship may grant me the protection.
You are mailing a plate now?
Not now. I've called the clients. In case the Lordships can have it after lunch or tomorrow.
After lunch, not tomorrow.
Great.
Yeah. copy.
After lunch, I have some problem.
No.
This is not
No,
the
this is
matter.
another matter. Mr. Body, not your matter, some other matter.
Okay, sir.
You file a affidavit. This appeal, intra-court appeal, seeks to lay a challenge to a learned single judge's order, which to lay challenge to a learned single judge's order dated so and so, whereby appellant's WPC number so and so has dated WPC number 314 of 2016 has been negative.
No, my lord. My lord, that is 23414 of 2025, Annexure 1. 23414, Annexure 1, my lord.
3414 of 2025.
Your lordship.
Date is dated, it is dated 11/12/2025. First of all. In the said writ petition, he had called in question the order dated 30/11/2024, correct us if we err, made by the estate officer Bhuneshwar in OPP case number 01 of 2024 into brackets Q or Q capital or small. And also the order dated 23/7/2025 passed by the director of estates in appeal case number 64 of 2024 into brackets Q. First, next paragraph. Learned counsel for the appellant, having argued the matter vociferously, now submits that if a reasonable period is granted for vacating the premises in question, his client would not press the appeal. First off, this submission he makes on the instruction of the appellant. First off, who is your opponent?
My lord, is state officer.
State officer. Go ahead. Will give some reasonable time. Learned AGA Mr. Behura, on request appearing for the respondent officials, having opposed the petition appeal, now agrees with the proposal of the appellant to the above effect. Next paragraph. However, he insists that by way of caution, the appellant should file an affidavit to the effect that within the time to be granted by this court, he shall quit the premises peaceably and failing, the respondent should be permitted to remove him with the assistance of police physically. First off, you have to say that straightway I will quit this property on such date, and if I do not quit, they can make use of police for that purpose. All right? This is in addition to contempt proceedings by us. Next. In the above circumstances, this proposal, counsel for the petitioner is appellant is agreed. In the above circumstances, this petition is disposed of as having been withdrawn, granting a period of 3 months.
So grateful.
He asked 3 months. Granting a period of 3 months. 3 months. For peaceably vacating the premises without seeking any further extension. First, we will make it clear that this observation, the observation made in this order shall not be construed to the effect that the appellant is in the occupation of the subject land. Okay? Because tomorrow you may say, there is a proof that the judge himself has given 3 months for a cating. I am in possession. Therefore, we forget. All right?
As you lordship.
Item 11.
They pray for a copy during the course of the day.
Yes.
Grateful. 11.
Wait, please.
Yes.
My lord, in this case,
Yes.
the petitioner, my lord, challenges the order passed by the Central Administrative Tribunal, in which, my lord, in the original application, the interim order was granted after filing of a MA by the petitioner. But in the next date, the stay order was vacated and my miscellaneous application was declared as not maintainable. The case is like that, my
Please
lord.
repeat.
My lord. The stay order was granted annexed 23.
Now, where you were before the tribunal?
I before the tribunal
Yes.
that even though the order of the Honorable Tribunal was implemented, earlier order passed by the Tribunal as page 77 was implemented. That is with regard to grant of grade pay of 4,600
In your
in my favor.
OA number?
That is way number, my lord. Way number 3638 of 2022, which was disposed of by the principal bench. A batch of writ petitions was filed in different benches, Delhi, different benches of the tribunal, and it was transferred, all the cases were transferred and disposed of by the principal bench. This way, my lord, filed by the petitioner were disposed of, page 77, granting the benefit of 4,600.
On
My lord, 3/5/2024.
the benefit was granted to you.
Granted to you, since this was not
What is
granted,
that benefit?
benefit of grade pay of 4,600 at par with the similar situated persons. It was extended. My lord, after this was implemented by the Annexure 16 on 18/3/2025.
Implemented on
18/3/2025. Accordingly, my lord, my content petition was dropped, filed before the tribunal.
content.
Content, that is CP number 118 of 2025, was dropped on 27th of May 2025. And the notices were discharged.
27/5/2025. Yeah.
My lord, even though this grade pay was granted to me, but the corresponding pay was not granted. The corresponding pay, minimum entry pay was not granted. I filed an original application before the Central Administrative Tribunal Cuttack bench, praying that
OA number?
that is way number, my lord, 548 of 2025. I filed with a prayer, even though you implemented and grant me that 4,600, but I am entitled for the minimum entry pay at par with the similar situated persons you have extended. The tribunal issued notice to the opposite parties, and a date was fixed, you file counter. Soon after receipt of the notice, my lord, the opposite parties have withdrawn that implementation order. The order which was implemented and the contempt was dropped, they have withdrawn, saying that you are not similarly situated.
On which day?
That is 5/1/2026. Annexure 20. They have passed a speaking order saying that you are not entitled to get the benefit, even though the order passed by the principal bench was not challenged.
5/1/2026.
5/1/2026. My lord, I filed an MA before the Honorable, and also on 6/1, the next day, they have issued a show cause notice why the recovery will not be made from you. immediately, my lord, I file an MA before the Honorable Tribunal saying that once the benefit has been extended and the contempt petition was dropped, unless and until that order is set aside or challenge or a review has been made by the principal bench, the authority has no authority to opposite party has no authority to withdraw that order. That amounts to contemptuous, my lord. The Honorable Tribunal accepting my MA and issue notice to the contender to the opposite parties, and the order was stayed by the Annexure 23.
You said contempt came to be dropped.
Already dropped.
Then where is the contender?
They are not the contender. My respectful submission before the tribunal that amounts to contemptuous because once a drop, they have
to the opposite party, OPs it was notice.
My lord. That withdrawal order was kept in abeyance by the tribunal. By the order dated, my lord, 15/1/2026.
That MA number?
MA number 27 of 2026.
Thereafter, what happened?
Thereafter, my lord, the Honorable Tribunal directed the opposite party respondent, you file your response.
Further, what happened? All that is story.
And the next date, my lord, the Honorable Tribunal vacated the interim order and dismissed the MA on the ground that this is not maintainable.
MA is not maintainable. It was fresh cause of action.
First, if my MA will not maintainable, if that order of the implementation of the order will be,
then you seek restoration, the revival of your contempt petition.
my lord, that is separate thing. I will file before the principal bench. But so far as this withdrawal of the implementation order is concerned, my way also became infructuous. Because, my lord, I am claiming the benefit arising out of that implementation.
What is
See the page 136, paragraph 6.
136
order. Page 136, Annexure 25.
No, that is 125.
136 page, continuing page, Annexure 25, grouping 1. Paragraph 6. They could do the current council.
Sixth argument appears to be sensible. What he has argued appears to be sensible.
Then let's come to paragraph 7.
7, 8 also.
Yes. What is my humble
Case for admission. It has come for admission.
That is.
Case for admission. Heard learned counsel. He should be playing front of the sitting with the court and that's what the court of what they got in Europe. Learned counsel for the petitioner. First off, the prima facie case is made out for issuing notice. First off, learned the DSG Mr. Paddy on request appears for the OPs. All OPs?
All OPs, but Lordship may take less than my learned pen may take notice to 2 and 3 because
OP number 1, emergent notice 2, OP numbers 2 and 3. First off, any interim order you have sought for?
My lord, so far as that withdrawal is.
That counsel for the petitioner draws attention of our attention to his application in IN number so and so supported by affidavit seeking interim protection. First off, he repeats the submission made before the tribunal, which has been recorded at paragraph 6, 7 and 8, 6 and 7 of the interim order. First off, a prima facie case is also made out for grant of interim protection. First off, in the above circumstances, applications having been favored. What is the interim protection?
The interim protection that withdrawal order and the recovery by the
We will say recovery be stayed.
Well, so far as withdrawal order, unless that withdrawal order is stayed.
Staying withdrawal order makes no sense.
Well,
the OP number, OPs are directed not to defect any recovery pursuant to the order put in challenge in MA number
27 of 2026.
27 of 2026. 26. Pending up to 2026. Yes.
Item 12.
My lords, kindly permit me, my lords, to appear for the.
IA for amendment has been filed.
What was
The council arguing is available on VC. Will be arguing on VC.
Yes.
My lords, my apologies, I could not be present today physically before your lordships, my lords. My lords, this is an application for seeking certain amendments under the writ petition which is pending before your lordships.
It's not been served.
Your lordship, only one copy has been served. I will serve the rest of the copies by tomorrow latest.
Okay.
The order, in fact, is also applicable, my lord, under section 111. The order challenge is also
111?
applicable, my lord,
Of
of Electricity Act.
But the
The order of the
then
OES.
don't put that order in operation.
But the order challenges of OP number 1, I am for OP 7. But that order is, my lord, applicable under.
I am appearing on behalf of Mr. Amit Patnaik for OERC. There are 4 prayers. Prayer A and B have already been this honorable court has directed that they are not pressing these 2 prayers. Prayer number C and D challenges the regulation issued by the OERC.
Then that only. Regulation, validity cannot be
Validity of
challenged
regulation,
before any other court or authority.
That's right, my lords, it's a challenge to a regulation. And also, my lords, there are other aspects. May I request your
Report 7. But if he is sent to appeal, that appeal will be heard and decided on the basis of the regulation.
Yes,
Grievances
your
against the regulation.
your lordship, sir.
Take notice because the validity of regulations has been sought for.
It's already, when notice has been issued, they have filed an IA for amendment.
Amendment.
They are not aware of.
You
what
give
the-
copy. All of you do.
Well, the respondents are yet to file a counter in this.
You file copy because now you have taken up application, filed application. Let them file counter to the main petition and to the application also. Otherwise, for this one, for that, another.
But I am for OP number 4, your lordship.
You appear.
4.
So it's appearance you put.
Sir, I am appearing for a union opinion, OP number 3.
Copy number 3.
I am for OP 7.
Give your name.
But
Just
then-
place a paper.
Yes,
For-
Yes, sir.
I'll request your lordships to record my appearance when it's in this.
Yes.
Lordship,
Yes, okay. Have you seen the faces of all of them? Dazzling faces. Yes. Remember the face and the name. And retrieve it. Call up to 2 weeks, full stop. In the meanwhile, copy of application shall be served by the petitioner side on all the learned advocates representing the OPs. Otherwise, application, full stop. Otherwise, application runs risk of dismissal on that ground itself. Yes.
Item 13.
Obliged.
13, my lords, order dated 19/1/2026. My lord, the issue notice by Lawrence seniors appearing for the respondent. We have copy served on 27th January 2026. Ma'am.
Interim order has been granted now.
Yes, ma'am.
And appearing for OP number 1.
That's the only, the next date or
Yes.
covered by that Mundila money.
Yes,
Mundila money.
Covered by that. So, my lord, kindly allow 2 weeks time to file reply. Fix a date after 2 weeks, my lord, so that matter can be taken to again.
For OPs. You appear for OPs.
OP 1.
OP1.
Yes.
So it appears for OP1 and seeks a short accommodation for filing 2 pleadings. First, call up to 3 weeks. For OP number 2 and 3.
Well, my lord, only two is a formal party, the cat, my lord. So the party that is not necessary. For formal OP, ma'am.
Steps to be taken for serving OP number 2. Individual steps to be taken for OP number 2.
The interim order.
Interim order to continue. Finish the problem.
Item 14.
My lords, item 14, I'll supplement my argument to 2 points, my lords. My lords, the
Whether liquidation is that computing whether to say the promotion process began. Liquidation is the date,
my lord,
or when the DPC met is the date.
my lord.
That is the only case.
My lords,
Yes.
my lords, what I humbly submit.
Yesterday,
The
Mr. Murthy were held up in another.
Trying-
Then after they sought for time, then I posted into this state.
My lords,
That is framed under Article 309.
That's what. That's
my
what he said.
lord, my lords,
He wants to say.
Yes, sir. Yes,
my
let him
lord.
Clear you.
My lord. My lords, the strength was enhanced on 17/5/2011.
Give them copy of the
17/5/2011
First another.
enhancement was done, my lords. After that, my lords, this is 50% by way of direct recruitment.
Yes.
My lords, 50% direct recruitment and 50% by way of promotion, my lords.
Quota system.
My lord. On 17/11/2011, OPSC made advertisement for direct recruitment.
17/11/2011. Yes.
My lords, kindly see this. This is part of the record for convenience.
Give that. Take that.
For direct recruitment, OPSC had made the advertisement. For promotion, this was notified, my lords. 10/1/2012. Calling for the CCRs and all reports by 15/2/2012. That this order was not challenged or time was not extended, my lords, till DPC convened, my lord.
This is a intradepartmental.
My lords, it is
an order.
Government, I am directed to, my lords, language.
It is addressed to whom?
Addressed to all the authorities.
But how they are concerned?
My lords, unless these CCRs are not with the records, DPC cannot evaluate the.
No, you are saying this is not challenged.
My lord.
It is not addressed.
My lords, what I humbly submit, the time given is 15/2/2012.
To whom?
To all the authorities to send their CCRs.
This is addressed to the controlling authority.
Yes, my lord. That is what I have said. My lords.
Time limit you have given is to the authority. Authority.
My lords, what I humbly submit, my lords, by the time DPC convened, this was not extended or further letters were not issued. So, my lords, the
whatever information collected up to this.
That is 563. The
Mr. Vijay and Mr. Dehuda speaks that pursuant to intra-departmental communication dated 10/1/2012 sent by Undersecretary to Government to Undersecretary of another department.
Commissioner of
to the Commissioner of Commercial Taxes. The requisition was made for collecting the information and necessary documents from the aspiring promotees on or before 15 to 2012. First of all. That was the cutoff date. He adds first one. He further submits that all and whatever information and documents that have been secured on or before the cutoff date were alone the subject matter of consideration by the DPC. Therefore, obviously, it was in respect of 567.
My lord,
563 vacancy that could not include the newly created additional posts. Yes.
my lords. Another, my lords, Rule 10. Once again, I will less, my lords. Rule 10(1). The board shall meet at least.
So, why don't it's A1 in.
My lords, that is filed in another affidavit, but it is in the pleadings.
In the record. Okay. We put it in a separate envelope. If we were they give not, it would be an envelope so that it becomes singing for us to give dictation. Continue that.
Now, my lords, I am placing Rule 10(1) again, my lords. The board shall meet at least once in a year, preferably in the month of January.
Which one?
Rule 10(1), my lords. That is at page 44. My lord. The board
once in a year.
Once in a year, preferably in the month of January, to prepare a list of officers suitable for appointment to the next higher grade, taking into account the existing vacancies and anticipated vacancies for the year, my lords. What I point out, for the year.
Correct.
My lords, this DPC, though it has been done in December, my lords, in the proceeding, it was done for the year 2012. 2012. So, the year is.
It should have done in January 2012.
12.
And it has been actually done in December 2012.
December because of the litigations and other things. And my lords, the year defined in the definition, that calendar year. My lords, my humble submission is that the enhanced post will be considered in the next year. That has been done also, my lords.
We were drawing our attention to Rule 10 of what rules these are?
My lords, this is Orissa Taxation and Account Service Rules 2011. Orissa Taxation and Account Service Rules.
Ideally speaking, the DPC has to meet in the January of every year. However, the DPC was constituted on.
Constituted earlier, my lords, before that is
constituted
17/5/2012. First
17/5/2012. Met on
22/12/2012.
2012. Pursuant to the requisition and had the requisition. 71. Therefore, the vacancies otherwise available because of enhancement of posts, sanctioned posts, in on 7/12.
My lord, 6/7/2012.
6/7/2012 would fall outside the consideration of say DPC, and further that they would become the subject matter for the DPC in the month of succeeding years.
2000. And my lord, in the DPC proceeding itself, they have prepared the list for the year 2012 only. Even in the last month, that was for the year 2012. My lord.
How that?
No, that is there.
How that alters?
My lords, because of the Rule 10, it was supposed to be done in January, my lord. And accordingly, on 10/1/2012, all the records were called for, the requisition was made.
You mean to say, ideally January is the month. But because of so many factors, it will not happen.
My lord, January. Because of litigation, so
anything.
My lord.
If it happens in some other month,
my lord,
it should be deemed to be held in January itself,
my lord,
for all practical purposes.
It was deferred only, my lord.
It has never said.
No.
That's that. In the given year, if the DPC is held, it should be deemed to have met in January of the said year itself.
My lord. And in the subsequent,
because of the text of Rule 10(1).
My lord. In the subsequent year, they were considered and given appointments. That was not been challenged, my lord.
He adds that for the subsequent year, that is 2013, the DPC met, when it met?
My lords, it is notified. No.
December
Yes.
2012.
No.
Yes.
So that.
No, that is different, my lord.
13.
It has to be in January, February of the success.
My lord, immediately. I am not getting the.
I have a list of dates.
Can you answer why?
Yes.
Yes,
I will. My lord,
give that.
My lord, allow me to give a list of dates. Having all this.
We are asking you the date. When the 2013 DPC met. Till that.
2013 DPC, as my learned friend for the state was saying, it met, my lords, on.
My lords, 28/2/2013.
28/2/2013. And it had taken into account the vacancies, include regular vacancy,
my lords,
including.
I'm sorry, my lords, 4/12/2013.
Yes,
4/12/2013.
Then it makes.
My lords,
it cannot be for 2013 at all. How will you meet for 2013 if you had held it for 2000? See, you have already held one committee.
My lord.
One committee functioned in December itself. Another committee also in December.
No, next year. Next December.
In 2013.
If I can explain what my friend is trying to submit.
We are asking one clarification. Nobody is answering. Verbose. We are asking a date. When the second DPC met?
4/12/2013.
13. 13.
Promotion.
But on the 28/12.
4/12, my lord.
2013. We are coming back. Kindly be specific and pointed. Be pointed.
So I have
for articulation.
2 pages.
We'll permit you to argue. But when we ask some questions in the middle, confine your answer to question. When we ask, give that. No other argument. Yes.
My lords, the second batch was given promotion on 7/2/2014, my lords. The persons aggrieved, my lords. 7/2/2014. Second batch.
Okay, pursuant to December 2013
Yes,
DPC.
my lord.
Pursuant to this DPC, the promotions were accorded on
7/2/2014.
7/2/2014.
And they have accepted it without any protest.
Who are they?
The
Interveners.
my lords.
The promotees, including the interveners
And the opposite party, no?
and OPs also.
OP1,
OP1
And OP number 1. In WP number?
My lords, so far OP number 1 is concerned, I have another.
No, as a matter of fact, he also was the promotee.
Yes, in second batch.
He also did not challenge it.
My lord. My lord.
Mr. Mohanty, whether they were trying to challenge it.
Let him finish.
No, we are asking, did he challenge it? You sit down and answer, you need not stand up. You are much senior to us.
Not your lordship. No, that's not. Court is a court, my lord. We must know how to protect the dignity of the court irrespective of the age who occupies the chair.
Whether you are trying to challenge it, that promotion.
Yes, my lord, your lordship may kindly see the impugned order.
No, we are only asking you whether he had challenged
that DPC proceeding itself was challenged, my lord, in 2013, my lord.
First one. I am talking second.
Second one, you have not challenged.
The second one, question
that question will not arise. Because if you succeed, automatically you will figure out
yes,
or contention.
There, in fact, that order is impugned here.
My lords.
They which I challenged.
My lord, so far.
First order.
First order, your lordship page 24, your lordship will kindly see. 20.
Mr. Behra, you said when the DPC met in respect of first DPC.
My lord.
When promotion was granted in the.
My lords, that was given on 30/4/2013.
First DPC met on so in 22/12. First DPC is
30 April 2013.
22/12.
30. No, 34.
DPC.
Yes, my lord. Pursuant to
22/12. DPC. Promotion. DPC recommendations. Promotions were accorded on
30 April 2013.
2013. Last sentence? No.
Only just
last paragraph.
only one small, since my lord is recording, my friend would agree. On 34/13, the OPOC approved the DPC recommendation.
Not recommendation.
Approved the recommendation.
That's all. Not
Appointment was
promotion.
given
Not from.
thereafter.
Promotion was granted when?
But nothing boils on this. But since my lord is recording, I'm just.
Wrong, to put the record straight. That cannot be the date then.
My lord.
Promotion was given on which date?
Mr. Krishna, you have also put in your date chart.
Yes, no.
Approved DPC recommendation.
Yes.
My lord,
Promotion to
6/5/2013.
6/5 was the date.
6/5/13.
Under your rules, the role of the OPSC is there even for promotions.
Yes.
Therefore, they gave the approval.
Yes.
But when the promotions were given effect to
6/5/2013.
13, my lord.
30 remove the 6/5/2013. Thank you for correcting us.
My lord. My lords, so far the first case is concerned, Mr. Senior's client is concerned, who approached.
All are your seniors only.
No, my lord. My lords, his case was considered in earlier DPC. My lords, kindly come to page 86. This is last.
That is the OP number 1.
My lord. Kindly come.
OP number 1, that is the client of senior Mohanty was given promotion on
No, he was considered in the first DPC,
was considered in the first DPC,
but otherwise found
in December 2012.
and otherwise found not
Was not found suitable.
No,
who is
that is not correct. Let him place a paragraph 86.
my lord.
Stating there is a suitability.
My lords, it may also be submitted that the name of the applicant was within the zone of consideration and he was considered on the basis of available CCS for the period 2006-7 to 2010-11. But his name was not recommended by the DPC as his name could not find place in the list of your category as per the seniority in the gradation list.
He was not recommended from promotion. Only this. Because we read something.
That is.
So, my lords,
Because of the.
He had challenged the first DPC proceedings.
Yes.
my lord.
And the promotions accorded on that basis.
My lord.
Okay.
So, my lords, they have not challenged the second promotion, so they cannot.
The Vedanta says the second DPC proceedings were not challenged by senior Mohanty's client, that is OP number 1.
All, my lords, all.
Not by interveners also.
So now after
And therefore,
they cannot.
they have acquiesced
My lord.
in the second DPC proceeding, and as a consequence, they should be stopped
My lord.
from challenging the its regularity.
My lord. My lords, I conclude.
You start.
What the tribunal said.
Tribunal, my lords, without explaining anything, my lords, came to conclusion that 753 was announced in July.
That also ought to have been considered by the first DPC.
You make review DPC.
That was the prayer in the waiver.
That in the
DPC and what 12 DPC in respect of all the 750.
my lords, that was made by client of senior man. No, all others have the.
Court is asking what was the prayer.
My lord.
He was made
No.
Also, Marty, better.
Now,
Different.
yes, who will begin from the other side?
So that
I do not know. Between you amongst yourselves, that is
if you are not
We are opposing each other. So.
you are opposing each other.
I am the opposite party number 1.
Then we will complete, we will hear them.
Yes.
They can reply.
All right, I was only managed to put certain facts into place, which was
Told by Behula.
recorded. But I may be allowed 5 minutes time.
Oh, we'll give you. Not 5 minutes. Many more minutes.
Before they begin, let me, I don't want your lordship to be give certain wrong facts.
You are not say any wrong fact.
You want to add?
In the I am giving the background. In the year 2009, my lord, Orissa Finance Service was restructured. Then there are 2 wings.
Yes.
2009.
All right, no issue. Afterwards, you can give the date also.
Your lordship, I kindly take this resolution, my lord.
Yeah.
Has your lordship got it?
Yes.
Lord, your lordship kindly glances at
Why the resolution dated 28 February 2009. Yes, it is structured. Agree.
Then it was bifurcated. One became finance service rules and another became Odisha taxation and accounts.
Kindly come to para 2.
Para 2. Simultaneously with view to providing a for the growth of dedicated cadre of functionaries with professional expertise in financial management and field execution thereof. B, for the systematic career development of the functionaries of the Odisha subordinate services, it has been decided to constitute a new cadre, namely Odisha Taxation and Account Service, with cadre strength of 345. Then, my lord, your lordship says 3. Since sufficient number of officers in OTS cadre shall not be instantly available to man all the posts in the cadre officers, shall discharge the functions of this post. Then, my lord, this will govern the next page. Sorry. Your lordship will kindly see the 7, the amendment 2, or the formation of the rules regulating recruitment to the restructured Odisha Finance Service and the newly constituted Odisha shall be finalized in the prescribed manner within a period of 3 months. So, this, however, this rule came, finance service and rules and the account service rules, audit and account service rules, came to force on 6 June 2011.
Pursuant to restructuring.
With which rule we are concerned?
And more particularly, because of paragraph 8 of the restructuring resolution dated 28 February 2009, the rules came to be amended. Then what happened? What amendments?
The present rules that was placed before your lordship, that rule 4, 10, 7, came into force on 6, 2,
4, 7, 6, 7 and 10.
4, 7, 10 and 15.
15.
Because they are banking on 15 also.
It was notified.
From
17/6/2011.
17, 6, 2011.
And they will come with effect from 28 February 2009.
Yeah.
Then
let them argue.
Then, my lord, that about that DPC proceeding, my lord. Your lordship may kindly grant, but one DPC proceeding held in 2011 December. That is admitted.
Correct.
The next DPC held in December 2012.
Yes, correct.
That is annexed. The next DPC held in December 2013. So it is not the case that after 2011, 2013 DPC was held. In between, there was a DPC in 2012 also.
One more DPC was there.
2011, one DPC was there.
2011 JPC we have not recorded.
Oh. All right.
No, otherwise also not relevant.
All right.
All right. Now, if you permit them, they will argue. Then you can reply.
No, reply. I will make a submission. Factually, they got promotion earlier because their cadre restructuring was done simultaneously. Rule came into force and the same thing. But the
rules came in February 2011.
No. That came in notification 6 June 2020.
20th February.
Odisha Gazette 6 June 2011. That is page 17 of the writ application. Odisha Gazette টা লেখা হয়েছে এটি আমাকে এটা কোন
17th.
আচ্ছা
Yeah. All right, we have rectified. Yes.
that is given.
Yes.
So now your lordship have to only decide confine it to the interpretation of Rule 10 and Rule 9. Well, like other
1 and Rule 9.
Like other rules, there are central government services rules, IS rules. The process will start from the date of the requisition.
Provided rules say that.
The rules say
That's
that.
what Madam is saying now.
That is what is our case also. Because the language yourself is 9 is the constitution of the selection board.
Committee.
There shall be constituted a selection board consisting of the following members.
Correct.
Then, my lord, 10 says the board shall meet at least once in a year,
January.
preferably in the month of January. But your lordship will find that successively every year DPC is being held in the month of December. Am I clear, my lord? So, and it is the board which is empowered suitable to the next higher grade, taking into account the existing vacancies and the anticipated vacancies for the year. That means on the date of the meeting, the existing vacancies should have been taken into consideration. That is the only point, my lord, to be decided. And what the tribunal says, my lord, tribunal says, all right, they have been promoted from their quota. If the cadre strength is taken to have increased, then more 58% or so will be appointed. So without disturbing their
Seniority.
without disturbing their promotion,
But the seniority will be altered.
the seniority, you consider whether these people are hold a DPC, you consider as against the existing vacancies on that day,
Which will include enhanced.
enhanced that, and if you find them fit, then give them promotion. But instead of setting aside, prayer was to set aside the entire DPC proceeding and the consequential action. Instead of setting aside, he says that already done. So therefore,
You do it for these people.
what these enhanced people, being whoever comes into the zone of consideration, you bring them. Because you are denied, at least I was denied, because I was included in the zone of consideration, but because found fit, but no post was available because they took the earlier strength, not the enhanced
That
strength.
is 600 order. 563.
560.
Not 700.
Not 700. So if that 700 would have been there,
You would have been selected.
we would have been selected because I was not thrown out in the merit, I was thrown
For
out
want of vacancy.
want of vacancies. That is what I want to make it clear. Now let them submit and thereafter we will publish.
One prayer, Lordship. After everybody finishes, I will submit. Addressing everybody.
After you submit, I will submit.
Everybody. No.
Yes.
In fact, I don't want to join issues on that fact. State is the
You are all interveners.
we are interveners.
Madam's clients are also interveners.
Interveners. States
But opposing interveners.
opposing interveners. We are supporting the state. It's the state's writ. So probably the state should have the right to rejoinder because they are the petitioners here. State's writ is being argued by us. Now,
And
we have,
the opposite parties would be excluded from selecting some.
I think that's how the rejoinder is from the petitioners. Your Lordship may kindly see the list of dates I have given, short list of dates.
Your intervening application, impleading applications are allowed.
Allowed.
Allowed as interveners or parties?
Of parties.
Party.
OP numbers 13 to 50. I have given a short list of dates. Your Lordship may just see that.
All right, go ahead.
This date 17/6/2011, Orissa Taxation and Account Service Rules 2011 was promulgated. Rule 4, the relevant rules which all of us are discussing are mentioned here. Rule 4 deals with the sources. We have also given a compilation. My Lord wanted hard copies of the impugned judgment and all. That I have given. My Lord may also kindly take that. My Lord wanted the hard copy of the impugned judgment and everything.
Correct.
So in that we have
made one compilation.
Yes. We are giving copies also to my friends. So here, my Lord may just
Can you say the gist of your submission so that in the light of that we can interpret all these things?
My Lords, the order of the tribunal is under challenge.
Correct.
First ground of
on the ground that it may affect your position.
Yes. So first ground is
your promotion will be retained, but ranking is likely to be altered. Because of that, you are there.
Because of that. So en bloc, a number of people will go ahead of us, and we have not been included as parties. So non-joinder of parties is the first ground. Second is non-disclosure of a vital document, which I will show from the record itself. That's the second ground. Third ground is, my lords, the policy decision of the state. It is the prerogative of the state to fill up how many vacancies they want. The tribunal has overreached on that count because the courts in exercise of judicial review cannot direct the state as to how many posts are to be filled up.
But that may be loosened.
My lords,
earlier we were.
My lords,
it is for the employer to decide whether to fill up or not.
My lords,
whether to fill up so many posts or vacancies out of so many available.
My lords,
but that view is loosened.
That view is loosened depending on the facts. Now here, if your lordship, that's why I gave the list of dates. If your lordship would see the facts in a holistic manner, the administrative exigencies would have made it impossible for 753 to be considered. That is what my learned friend for the state was trying to submit. So these list of dates, my lords, may kindly allow me to show. First one itself, Rule 4 provides that there will be 3 sources. Now DPCs for these 3 sources will be separate. This is so 50%, my lords, is direct recruits.
Direct recruits. Yeah.
That's one major chunk. 30% is promotion. 30% is promotion category. My learned seniors for the interveners who are opposing the state, they are for this 30% promotion category. Then we are, my lords, from
for
this
20% you are.
For 20% selection
20%
category.
is by selection.
By selection.
30% is the seniority cum merit.
30% is promotion.
Yes.
Promotion on what basis?
Seniority cum merit. Now, so these are the 3 sources, 3 separate DPCs. This is a vital fact because if the interpretation to Rule 10 is given as if on the date on which the board sits, that will be the commencement date, then these 3 categories cannot come in. So, my lords, a purposive interpretation of these rules in a conjoint manner would be that if the entire scheme of this rules is to be given effect to, then 10 has to be considered in the background that from the date on which the recruitment process begins, that would be the date of commencement. And for that purpose, if your lordship would see the dates.
Recruitment process means for 50% or this 30%?
All 3, my lords.
All 3.
Because separate dates. Here, if my lord would see the list of dates, first advertisement was issued on 17/11.
For direct recruitment.
For direct recruitment. Keeping in mind 563.
Keeping in mind 563.
563.
It was issued on which date?
17/11/2011.
But as on that date,
the N was not enhanced.
It was not enhanced.
Yes.
It issued only for that.
Correct. So what the learned state is rightly submitting is, on that date we couldn't have taken it to the anticipated enhancement which came about, my lords, on July next year, 2012. So 6/7/2012, the strength was increased. The advertisement, my lords, was issued on 17/11/2011. And next date, my lords, is important. Inter se seniority rules amongst these three. That is also something which may fall for consideration. That was amended on 22/12/2011.
The warrant for your argument
My lords.
that the recruitment process for 50%,
My lords.
promotion process for 30%,
My lords.
and based on seniority come merit, and 20% promotion process on selection basis
My lords.
should simultaneously happen. Where is the warrant for that argument?
No, we are not making that argument. All that we are saying is, this is the scheme. The process is started on 3 separate dates. That process commenced prior to 6/7/2012 when the cadre strength was enhanced.
No, why you are mixing that the DR quota recruitment? We are unable. At least I am unable to comprehend.
My lords, I will, my lords, explain. The stand of the learned seniors for the interveners who are opposing the state is that Rule 10 on a standalone basis should be taken into account.
Correct.
And since Rule 10 says that it has to be the cadre strength on the date of the meeting, hence 753 should have been factored. That is the submission.
Correct.
Now, how in the facts of this case, Rule 10 cannot be implemented in that manner because the scheme of the rules is such that it has to commence in a phased manner. At least that is what the state has done in this case.
State has done in that way is one thing.
My lords.
Statutory scheme is like that is another.
My lords.
There is no such statutory. Factually, state has done is true,
Well,
apparent from the record.
My lords.
But because state has done that way, there is a scheme in the statute like that.
No, there is no
That
scheme.
argument,
No, there is no scheme. But the rule says that there are 3 sources.
That understood.
My lords. So from these 3 sources, the process was started on 3 separate dates.
Separate, bound to be.
Yes. So all that, my lords, I wanted to submit is that the process begins on the date of requisition, and then on 15/2/2012, the last date was given to submit all of these documents. So on 15/2/2012, the cadre strength was also not enhanced.
Correct.
So that state that Rule 10 cannot be implemented in the manner in which they are submitting is my further submission. Because administrative exigencies would make it impossible to implement Rule 10 on a standalone basis, given the scheme of this promotional exercise.
No, that scheme we are asking you. You are structuring your argument on the premise that there is a particular scheme.
My lords.
In respect of TR, 30% seniority cum merit,
My lords.
and 20% merit cum seniority.
My lords.
Where is that scheme?
That my lord may kindly see Rule 4.
Rule 4.
Rule 4 of the rules. That in that compilation it is there, page 21. Page 21 of that compilation.
These are 307 proviso rules,
Yes.
309 proviso rules.
Yes, 309. May I place that? Page 21, Rule 4 is there. Clause A deals with 50%. Clause B deals with 30%. That is for promotion.
That is which section?
Rule 4, page 21, first.
Sure. Rule 4B.
4A is 50%
A,
for
B, and
A, B, and C.
What Rule 7 says? Because 4C refers to Rule 7.
My lord. Eligibility criteria of selection. No person under C or 4C shall be considered for appointment unless and so the basic for
Outstanding merit and etc.
my lords. Then the next page, page 23, Rule 10, which my opponents are relying upon, that is there. Then Lordship should allow me.
The whole case depends upon, essentially, the meaning we assign to the expression existing vacancies.
If I can,
that also can be decided if scheme is also kept in your VVs, your submission.
If I can place it in another way, let us accept for a moment that what they are saying is correct. Rule 10 should be the beginning. Then the process of collection of papers and everything has to happen in one go and has to come in one go to the board.
Correct.
The rules in this case, the rules don't specify, they are silent. My lord is absolutely correct. The rule doesn't say that it has to go in this phased manner. But it also doesn't say that it has to go directly to the board under Rule 10. So the rules are silent there. And there, my lords, the Honorable Supreme Court says, when the rules are silent, it is the prerogative of the state as to go about, as to how to go about this recruitment process. Those judgments I would show.
Now, any judgment interpreted the expression existing vacancies? There are judgments.
Yes.
Go to, where is the, why disappears very often, like rainbow. Do you have any judgments on existing vacancy? There are.
Here, my lord, I of course, about falls from the court, I will have to research on that. But here, my lord, there is no dispute that till 6/7/2012, the existing vacancies were 563. After 6/7/2012, it rose up to 750. Now, the question is, in fact, my lord was absolutely correct when my lord posed that question, that when does the process begin for promotion?
Correct.
My submission is, in the context of this case, it has to be construed as to the date in which the process was commenced by the interested departments so that the board can meet and take a call on it. And if your lordship would allow, I will, as I proceed, my lords, I would show that they have also been considered pursuant to the vacancies as and when it has arisen. And that kind of latitude is given to the state because unless it is shown that you want to handpick somebody or you have a select person, unless that kind of arbitrariness is shown, that kind of latitude is given to the state so far as recruitment is concerned. And in the facts of this case, probably this list of dates would show that this was, because there was an intervening stay, all those facts have been shown by my learned friend for the statements. So in the circumstances of this case, there is no such arbitrariness is what I wanted to show. And Rule 10 has been complied with in the manner it can be done. And then my lords may kindly see the other aspects.
Why the strength came to be increased? Because need, requirement.
In fact, in 2011, it was increased sometime in 2011. The exact date, my friend would.
Yes,
I have given.
So it was taken to 563.
17.5.
From 345 to 563.
My lords.
Correct.
So it's in quick succession that
when that was done.
That date, my lord.
17/5/2011.
2011.
I have given that.
Then the DPC happened when?
No, first DPC is 22/12/2012.
2012.
12. And that DPC was delayed because of an intervening stay order by the learned tribe.
They did not stay the DPC at all. It only said don't give promotion.
My lord, because of that, they wanted the stay to be vacated. And after that, they Stay was vacated and then they proceeded.
Yesterday, it is being told that stay, there was no stay.
It was like crystal correct. There was no stay.
There was no stay.
No, may I
Says
just,
you proceed with the DPC, but short of making appointment.
That's right.
my lords. Now, thereafter, my lord, may kindly
Have you
see.
produced a copy of the interim order in this? No, Mishra. Mishra's.
My lords, in this compilation, I have not given.
Not.
Now, if your lordship would see, this OA, which all of them are banking on, was filed by one person. Only one applicant.
OP1.
OP1. Now, my lord, may kindly see, the impugned order begins at page 89 of the writ petition. And in this compilation, my lords, now, my lord, may kindly see, the OA begins from page number 1. And of the compilation, my lord, may see the prayer. At page 16. This was the prayer in the OA by one applicant.
60.
16.
Relief sought for.
Relief sought for. Now,
To direct the.
first is quash DPC under Annexure 7.
Taking into account 753.
Taking into account 753. Now, here, my lord may kindly see.
It is a review of promotions, actually.
Second prayer is for review. First prayer is to quash the DPC. Now, if your lordship would see Annexure 7, which was appended to the OA, that would be at page 50 of this compilation. Yellow flag, my lords, I have given for convenience that yellow color flag.
The first yellow color begins at
Page 50.
page number.
Hard copy. My lords, I'm sorry, those page numbers, the too many are there.
No issue.
Page 50, this is Annexure 7, produced by the applicant before the tribunal.
This is a DPC proceeding of 22/12/2012.
Well, and the first substantive prayer is to quash this.
Correct.
Now, my lord may kindly see this document, bottom portion. There is a mark given, serial number 1. My lords found that.
Yes.
Then, if your lordship turns the next page, it is serial number 4.
Which one you want?
My lords, this compilation, my lord.
Yes, that is exactly it.
It's also there in the digitized version in the writ petition also. For convenience, I have given the compilation. Now, my lord may kindly see Annexure 7, page 50, serial number 1, and the next page is serial number 4. 2 pages are missing. Even the para numbers, my lord would see.
Oh, that is what you argued that there was separation of documents.
Yes. And I will show, my lords, how the tribunal's order cannot be sustained because of this. So this is my convenience compilation, but it is matching the digitized records and the writ petition which was filed.
No.
And also the OA.
How those two
Pages are relevant. Yes. Now, my lord may kindly see, this is what was annexed with the OA. Now, my lord may see the document, what those 2 pages are. That, my lords would find at that pink flag mark, page 64 of that compilation.
What does it say?
My lord may see the next page.
65.
65. The OA numbers are given and the name of the OP number 1 is also given and his case has been considered.
True.
My lords.
Yes.
Thereafter, my lord may kindly.
Out of vacancy,
My lords.
it was not recommended. Is Mr. Month is.
My lord may see what was submitted before the tribunal in the impugned order. That would be at page 78 of this convenience compilation. It begins from page 78. This is the impugned order which the state is impugning. The applicant, who is presently working as ACTO in the range of so-and-so,
70. Yes.
has filed this OA with a prayer to quash the DPC proceeding dated 12. So this is the impugned order. 2 pages not given. And for direction to the respondents to convene DPC afresh for promotion to the cadre of so-and-so in accordance with Rule 10 of so-and-so.
So prayer is called out.
Prayer is called out. Next paragraph I am showing, my lords. I am placing the name of the counsel because that's how it can be matched. Heard Mr. R.K. Biswai, learned counsel for the applicant. And then, my lords, the government counsel's names, Mr. Biswai's submissions are recorded. He says that there was an earlier direction in OA number 1983 of 2012. All those submissions are recorded. Now, the relevant portion would be at page 82. Middle portion. In reply, Mr. Biswai, learned counsel submits that immediately after the order dated 2012-2012 was passed in OA 1983 of 12, the copy of the said order was served by the applicant on the respondent authorities on the very next day, that is 21/12/2012, which is 1 day prior to the date of DPC meeting. In that view of the matter, if the authority concerned would have taken immediate steps, then they could have called for the CCR folder of the applicant to be considered for along with other similarly persons like the applicant.
To be considered along with other similarly persons.
My lords.
Yes. So confined to applicant.
My lords, that is correct. But he makes out a case before the tribunal that I have not been considered in terms of the earlier order in OA 1983 of 12. That case, that factual foundation is incorrect because the proceedings of the DPC itself indicated that he was considered.
No. Consider means
My lords.
consider as against the enhanced portion. That is the whole fit and substance of the case, regardless of the language.
My lords.
Language has, we have linguistic barriers. Firstly, it is a foreign tongue.
My lords.
We are not born in Oxford or Cambridge. We are from Cuttack, maybe in this area. The gist of the case is simple. What he says, according to him, as we have understood. The DPC considered the non-revised vacancies, posts, and therefore that is wrong. It should have taken into account 700 odd posts. Keeping that in view,
My lords.
if that were to be done, I would have been selected.
My lords.
Since you confined it to 600 odd and excluded the enhanced strength, I have been deprived of that.
My lords.
That is only the case.
No, then my lord,
Regardless of the, no, you were saying 2 pages are not produced.
those 2 pages considered his case. Before the
No, he
tribunal.
said that only.
No, my lords, but before the tribunal, the submission is that it was not considered.
Oh, but he
All right, but
considered in the
that-
same. Appointment has been not recommended. It means not recommended.
No, but
You
clear-
can't, sir, we are reading the pleadings.
My lords.
The Apex Court said, while construing the pleadings, common sense cannot be kept in cold storage. This is the sentence in the judgment.
My lords.
We have understood the case of the parties. They may ask for moon. That is no ground for denying Rasgullah if he is entitled to that.
My lords.
So your first submission is nothing that turns out from the missing document. The missing documents which would have made reference to the outcome of the case.
My lords.
Only that will be suppressio very, not anything else.
Now, my lords, that is something which is there. Now, your lordship may kindly see the other aspect. The prayer, my lords, in the OA. Prayer, my lords, prayer portion which I showed.
First one is quash.
My lords, first one is quash.
Second one is redo.
Redo, my lords. Now, the other question is, that whether redo vis-a-vis only the applicant or en bloc having all others in the fray.
No, order itself. Well, it cannot be. Even order says that.
The order says that, but then, my lords, these are individual causes. Now, suppose you make such an OA without including your seniors in that case. Then, my lords, the question, then these kind of OAs are not maintainable. Supreme Court has said a person who would be affected by the final order of a tribunal, unless he is made a party.
No, if wholesale is considered,
My lords,
he need not be made a party. On wholesale review,
my lords.
it need, and after all, the court is saying don't displace anybody. It is only question of
No, displacing is there. My lords, the order, in fact, OA doesn't say that displace. Give me senior antedating it from a previous. But the tribunal says that you give it from a previous date. So the tribunal
have already been promoted. Their promotions, their apple cart is not disturbed. Ranking undergoes change because of the review.
No, my lords,
If we agree with the review, that under to Rule 10, they have to do like this. Only then this question arises. Now you have said why it cannot be like that. That first argument is to be considered. Rest of the arguments.
No, next, my lords, may I just submit? Now, en bloc, if people come ahead of us, then we have a right to be impleaded as a part. Because my lords may kindly see that OA doesn't say that give us promotion.
How we will know whose senior he becomes?
Because by the time
the other process will take care of that.
My lord may kindly see, by the time this OA doesn't say that give us seniority antedating it from 22/12/2012. But the tribunal.
Whatever is given, that happens. If you redo it,
My lord.
wherever I stand, I stand. I may be at the rock bottom. I may be at the rock bottom.
No, but if the order of the tribunal.
Probably you mean that you have already earned a indefeasible right accrued in you.
We had the right to be heard. We had to be impleaded as a part.
Review is always. Review is under service jurisprudence. Review has to be in a wholesale way. It cannot be sectarian.
My lords. There, my lords, what the honorable courts have said, Supreme Court has said, that when it is en bloc for a benefit of a scheme, then it can be what falls from your lordship. That's the correct position. It has to be wholesale. But when it is involving promotional aspects, individual rights, then you have to implead. Here, my lords, none of them have been impleaded. Not a single person. So if it is individual centric like promotion, then persons who have been promoted prior to you, they have to be, at least some of them have to be made a party. Here, absolutely nobody has been. So then, my lords may kindly see, before the tribunal, no, so that on that ground, my lords, the OA is to be held to be not maintaining. That judgment, if your lordship wants, I can.
Non-joinder of parties.
Non-joinder vis-a-vis promotion. What falls from the honorable court is correct. If it is en bloc giving some benefit to a series of persons, one person has come, then that benefit can be given across the board. When it's involving a scheme or pension, something like that. But when
Is it your case that you were not aware of all these proceedings and therefore you did not get impleaded?
Yes, our basic case before.
Where is that? Where have you taken up a contention in your application?
No, my lord, in the intervention here we have said, then there are individual writs which we have filed challenging the order of the tribunal. Those have also come before your lordships. So en bloc.
On the ground that we were not aware of these proceedings at all.
Yes.
Only after coming to know of that, we have filed that petition.
Yes.
Where is that such condition?
That my lord, in the connected writ is that.
One read, we need one sample.
And
one sample.
We will show that, my lords. Just
Can we come in the afternoon? Come in the afternoon. Yeah. Item 14. So you have two contentions. Number one, in terms of the extant rule, there is a kind of scheme that emerges. And scheme contemplates, because under 10 itself, 10.1, 10.2, 10, that is ABC. Yes. ABC. That's not 10. It is which is that? 4.
4 says that three sources. But my humble submission is that
Yes.
Rule 10 cannot be implemented in an isolation without taking into account the previous rules under Rule 4.
Rule 10, read with Rule 4, gives an impression of there being a scheme, because it is 50, 30, 20.
Yes.
Out of same vacancies.
Same vacancies. And 3 separate DPCs.
Separate DPCs.
So for 10 to be given effect to on a standalone basis, one has to completely then shy away from the other rules. Because 2M also says calendar year.
But for recruitment, there is a whole lot of a different procedure. Advertisement, written examination, Viva OC.
Yes.
Viva OC is also there. Yes, interview is there, no? Yes. Interview is there. Viva OC is there.
And also Rule 15.
Mr. Das, you wanted time in that matter.
No, I got time in other code.
Okay.
But my friend is taking time in that particular. I am to take time.
Is it?
There are some instructions.
But we have made him to wait whole day.
Yes,
because it's a 2017 matter.
yes, I was ready. All the way they are taking time. I will take only a week's time. Let's say 26th or let's make
accommodate some do.
26th.
Then we say sorry to you. Because,
no, because I have another matter, my lord. That is why I have got that adjournment.
Apex Court said we should discourage adjournment of old matters.
I will fall through. I have never taken time. Only sorry to interrupt.
Some other day. Good. Yes, sir. Can you articulate in writing and give your notes so that we will treat them in our...
Yes, I have given it, my lords, in this, after the list of dates itself, I have given it in 2 pages, very short.
The earlier one.
Today itself, after this list of dates, page 3. First is non-joinder. Non-disclosure I submitted. Then
non-disclosure, that 2 pages. 2 pages may not be. Non-joinder, yes. Anyway, you have given that. Non-disclosure of these 2 pages.
The tribunal records that submission. That since he was not considered, that is my
contention.
Another important facet would be Rule 15 of the same rules which was amended, that in this compilation, my lord, it is at page number 28. And in the writ petition also it is there at page 48. The lordship sees the compilation, how inter se seniority amongst these 3 categories is to be decided.
DR and the PR.
Direct recruit, promotion and selection.
Selection is also treated as PR quota by the Apex Court.
Selection is
except recruitment.
My lord.
Even 30 is a promotion. For the PR quota, nobody will dispute that. Even the
selection is also
PR quota.
Yeah. Now, inter se seniority, my lord, may kindly see that rule.
What it says?
At page 28, I'm just placing that. It was amended. The amended portion, amendment applies because all this happened prior to that. Inter se seniority. The inter se seniority of the officers appointed to service in a particular year shall be in order in which their names appear in the list furnished by the commission. Provided that inter se seniority of officers appointed by promotion under clause B of Rule 4 in a year. This phrase is important. In a year shall be fixed on the basis of their length of service in the grade and en bloc be senior to those appointed by selection under clause C of Rule 4 in that year.
So to these 30%,
My lord,
20% will be always above the 30%.
provided the exercise happens
In
in
that
that
same year,
But if it spills over to
that
2030,
question will not arise.
then selection will be higher.
Huh?
If the promotional category is selected in
Then
2000
30%.
30%, suppose 30% is selected in 2013, then the selection rate will be higher.
Because it is in 2012. That is obvious.
So this rule
applies only when 30 and 20 are considered in the same year.
Yes.
Where same year it is done, 20 will be above 30.
Yes. Different year, if it is different year,
Obviously different. That question will not arise then.
If it is different year, then 20 will be above 30. In the context of this case, my humble submission, the tribunal's order, if it is implemented, would violate this rule. Because 2013 promotees would en bloc march ahead of the selection category without them being included as parties. Because if this order of the tribunal is implemented, antedating the promotions to 2012, then en bloc this promotional quota will go ahead of the selection quota, and thus there will be a violation of this rule.
4C, in terms of 4C.
In terms of 15.
No, read with 4C.
Read with 4C. Now 15, I am placing that again because this is an important facet of this case. Provided that inter-se seniority of officers appointed by promotion under clause B of Rule 4 in a year shall be fixed on the basis of the length of service in the feeder grade and shall en bloc be senior to those appointed by selection under clause C of Rule 4 in that year. So that means in 2013, if somebody comes from the promotion quota, they cannot ride over the selection appointees who were appointed in 2012. So if the order of the tribunal is implemented and not interfered with, then this rule will be rewritten. So that and here, my lord,
that you have not taken up in your write-up. You give a small write-up on that. That you have not taken up. No,
my lord, point number 7. If the order of the tribunal runs contrary to, I will, if your lordship wants, I can.
All right.
I just wanted it to be handy for your lordship. I'll give.
Understood.
Here the question of non-joinder also would come in because
without them, this has been done.
Yes, without us being included, without the promotional category also being included. So the entire DPC is almost squashed, even though not touched with. So all these persons will march without them being found. In that context, your lordship knows judgment. Yes. My lords may kindly see this. 2021, 16 SCC 10. This is on non-joinder, my lords. I will give in notes, I will read this code.
Very good. You can give it to me along with it.
No, only the paragraph, my lords, if I can show you.
Which is this 2020.
Paragraph
yes,
9.
Prasad Rathuri.
Yes, my lord knows all those documents. Paragraph 9 to 12.
Refers to Pushpak and other things, perhaps.
Paragraph 9, the contentions are recorded. 10, there is discussion on merits.
Yes, Pushpak
and this
is
was
also referred.
And this is review DPC. So facts are similar. And towards paragraph 12 end, they say that the Honorable High Court committed a grave error. The High Court committed an error in directing review DPC to be conducted without hearing the affected parties and without realizing that there was a likelihood of seniority of other officers being disturbed.
Yes.
Now, my lords, my humble submission is state itself in its writ petition, pages 14 to 17, has elaborately taken this ground of non-joint.
State has taken.
State has taken in its writ petition.
Okay.
And very vividly, they have discussed twice.
On how the tribunal has treated it.
No, so far, I must be fair, my lords. Before the tribunal, this contention was not taken in the state's count. But in the writ petition, they have taken.
They become wiser after suffering the orders.
That may be one of the things. Other aspect may be that the prayer in the OA was only to consider. It was not to give it from 2012. But the tribunal went a step ahead and gave it from 2012. And hence, this issue of non-joint, had the direction been simply
Only
set,
consider.
then things would have been completely different.
Because they would have given notice to rest of the people and other things.
And they would have probably been lower than us. So if it is only limited to consideration, then seniority doesn't come in. But the moment you give direction for seniority, then you have to hear. So that may be the reason. I'm not trying to defend the counter of the state before the tribunal, but that may be the reason why that point was not expressly taken before the tribunal. But here they have taken it repeated in the writ petition.
In your write-up, just mention that.
I would have.
Short, whatever articulation you have done now, in terms of that, give a write-up. It becomes easy for us to do.
I'm sorry, in fact, of not giving it in an error.
You have argued that. No. We are only making a request.
My lords, so far as I will do that, my lords, at the earliest. The other issue which I submitted earlier, that the state has a discretion not to fill up the entire post.
You said there is one judgment.
There are two judgments. If you lordship want, I can quickly pass them.
You make the notes and write the citation with paragraphs. That becomes very easy for us.
Should I give those judgments now?
May not be. I am aware of those judgments.
Yes.
That position of law I am aware. We are aware of.
My lord.
But specific decisions we may not be knowing.
No, my
because
lord.
Much of law.
Only, and of course, the dates I had elaborately, my lord, had allowed me to state the dates and the sequence of events in this case would not warrant Rule 10 to be read in isolation. So obviously, when the board meets, all the data has to come in a phased manner before that board. So 10 on a standalone basis cannot be given that interpretation which my learned friends are trying to give. And the other issue, my lords, would be that intervenes who are opposing the state, they are basically fence sitters. They were not before the tribunal. If the question is only with regard to my learned senior Mr. Mahanti's client OP1, then of course there's a direct order of the tribunal, individual to individual. Because my lord knows that these are all in personam matters. En bloc you cannot grant relief in promotion. So for a schemes, pensions, en bloc you can give. It can be in rem, but so far as promotion, it's an individual right. And all these interveners were nowhere before the tribunal. So, my lords, if at all the order of the tribunal is to be implemented, it could have been only vis-a-vis one person, could not have been converted into this mass litigation. When it involved promotion, particularly in the backdrop of that these people have not been impleaded. Without impleading the affected parties, you give en bloc these people a march ahead of them. So that in 2021 itself, the Supreme Court says, when you are directing for review DPC of this nature, you have to hear them. And at that time, rights in our favor had got crystallized.
No, all of them are here. Or few of them are here.
Few of them and
no, if we want to hear you, what will be ground on which you want to say that? Assume that we should notice to you, your party. So, and what is the ground?
My humble submission here would be that this defect of non-joinder may not be rectified at the appellate stage. That is one aspect. But even if, my lord, if these things we have intervened here, then the issue here would be that the same arguments, that state is not duty bound to fill up all the posts. The exigencies here.
But how can you take up that contention? That contention state can take. Then employees also can take that contention.
We can support the state. Had we been
Had
there,
they taken that contention, you would have said, yes, sir, we want to add to something like this.
my lords, here also we are supplementing. Had we been there before the tribunal, we could have defended this aspect. And
No, had you been there,
my lords,
the first contention you could not have taken because you are there, non-joinder will not arrive.
my lords,
But the second one, state's prerogative, perhaps.
my lord is aware that there are some judgments where it's a question of non-joinder of a necessary party. Those orders, my lords, are completely void vis-a-vis those parties. So from that angle also, if your lordship sees, these orders cannot be implemented.
We can't say wider. We can say they are not applicable to you.
My lords, cannot be implemented
As
vis-a-vis.
against you.
Yes.
That's all.
So then that itself would render the impugned order bad. And some of them say that unless we implead necessary parties, your OA itself is not maintaining.
Some of the judgments I have seen, all need not be implemented at all.
Some. If it is large, if it is in you, here not a single person. Here not a single person has been in. Right. And state rightly has taken that.
When it was filed, that OA was filed when?
Before the DPC.
Before
That's
that?
just after the DPC.
2013.
Before the promotions were given effect.
No, before the promotions were given. They approached it. Then that will be subject to the split payment.
Not before, my lords. The DPC is impugned. But person.
DPC as such does not give you much. Your promotion
My lords.
effected after the filing of the OA.
My lords. So
How he will know that you will be promoted? How he can foresee?
This judgment in 2021 is direct. Yes, sir,
2013.
Filed to 2013.
Page 38 of the data.
OA was filed on 5/2/2013.
12 to.
Huh?
12
to 2013.
I think you must have missed
12 to is the correct date.
2013. That is much before the promotions made of interveners. Promotions were given to interveners of that is Mishra's clients. Mostly Rautrai's clients also.
But the DPC impugned was of
2012.
2012.
Correct.
So in the DPC itself, the beneficiaries were mentioned. So they are wanting to quash the DPC recommendation without including the beneficiaries.
The recommendation
No,
are not public.
DPC recommended, where is the concrete right accruing to you?
But then once the DPC recommends and once there's a prayer to quash that recommendation, then persons affected would be affected by that.
That will be very.
Annexure 7 is the first prayer.
Promotions, if made it, I can understand. If promotions are made, as on the date he approached the tribunal, we can understand. But appointments were not given to you.
Before they are, my first submission is that when they are impugning the DPC recommendations, recommending promotion in favor of certain people, then they should have made parties.
No, where is your concrete right? Suppose if the government takes a decision to dig a particular borewell, and thereafter it decides, no, borewell need not be dug. All those who wanted to take a morsel of water should have been made a party, heard the matter.
Then my lord,
These are cases where concrete rights had accrued. We are going by the head notes, just I very cursory reading I did. There were cases where appointments were given.
So this case then my lord may take 2021. Once you direct for review DPC in 2014.
That was the case where promotion was granted.
Yes, in our case promotion granted.
Promotion is granted after he approached the court.
But there was, the tribunal didn't interfere with the DPC, directed for a review DPC. So the moment you are directing for review DPC in 2014, many rights have accrued. That is what this judgment says. The moment you're directing for review DPC, you should get
Review DPC of those who have been already promoted.
yes.
That is the case here.
We have also been promoted here.
Promoted subsequent to filing of the case.
No, here, my lord's order, the Supreme Court.
Let us see, when DPC was held, when they were promoted, when they had approached the court, the foundational facts of this case.
No, so far as our case, may I give the dates? Our case, we were recommended on 22/12/2012, and that was impugned.
Paragraph 7 of that judgment. Para 5. All they were
included in the.
They were given appointment orders.
In our case, my lord may kindly see.
You were given appointment, though you were recommended, which recommendation he had challenged. Rights of the recommendee are incoherent. They are not complete rights. Incoherent. And once appointment is given, your rights become coherent. That's how service law, service jurisprudence.
But if it relates back to filing, then during the pendency, some of these people were given appointments.
Correct.
But on the date
That
of
will be list pendants. List pendants.
what here, my lord, suppose the tribunal is directing for review DPC. Then in the interim, so many people. Now there was one more facet. How the order of the tribunal is vulnerable, which the state has taken. If your lordship would allow me, I'll place from the state's writ itself. My friend also did submit on that aspect. That would be paragraph, page number 70. In the first DPC, which was held on 22/12/2012, case of the OP1 was considered.
Now give one judgment. Even candidates who are recommended by the DPC are necessary parties. None of the judgments which you are mentioning, they do not hold. Para 5 says all they were given appointments. Then the question of upsetting the seniority arose.
The other issue here would be that OP number 1 itself had been recommended on 4/12/2013. Of course, in the DPC.
Yeah.
So once
in February, he went to the tribunal.
No.
February 2013, he went to the
So
tribunal.
the relief granted by the tribunal was already granted to him on 4/12/2013. Tribunal orders in 2014.
In usual course, you mean to say.
In usual course.
But then before that it was challenged.
Before that he had challenged.
It was challenged in the month.
He
of
was
February.
given in the second DPC.
Second DPC.
But he did not want. He says, in the first DPC itself, my candidature ought to have been considered.
My lords.
That would have happened had the DPC kept in view the increase in the sanction strength.
Now, so far as this non-impletion, all that I would say, my lords, the prayer in the OA was just to consider him
You
for
said
promotion.
that already, but court tribunal directed that.
From 2012/2012. So in the intervening, all those people who have been appointed, because tribunal judgment came in 2014. In the intervening, lot of people had been appointed. Their rights were taken away without them being implemented. That is my case.
That's all right. But that question is, all that, whatever they have been doing, is subject to respondents. The government should have been thought over and should have said, but there is already a case is pending. Whatever we are doing is subject to, in the ideal state would have worked that way. But when they have not said, the doctrine of lis pendens applies.
The other issue would be then there was no illegality so far as we were concerned. Our appointments were in order. There were no submissions as to why they would march ahead of us.
Not like that. If we agree with them which you are considering. That's all we are not saying. On the maxim ex nihilo nihil fit, out of nothing, nothing comes out. If next this maxim is applied in Mr. Mohanty's, senior Mohanty's case, then all these arguments will not arise. Anyway, just I think so that you can view in your write-up.
The other issue would be, of course, people who are not before the tribunal, them being granted relief in matters relating to promotion. They are fence sitters. That also I'll include in that. Fence sitters as interveners, they are now seeking relief.
You recast your the contentions which you have taken up in your
It is 2 pages.
2 pages.
I would elaborate.
I'll give it today only. Because if you give today, we may pronounce the judgment tomorrow. Generally, we are against keeping these things. We will not make them, we will not pickle them that way.
Tomorrow first 10:30, I think.
I'll give it.
I'm grateful.
Thanks. Yes, Mr. No repetition.
Sure.
Yes.
Sir, I'm conscious of the fact that and until as argued very exhaustively, you also
No, he covered most of the points.
Yeah, interacted almost all the points. I'm trying to not repeat it, not any repetition at the cost of repetition, maybe a little bit.
Incidental reference can be there.
Sir, my first point is also kindly look so far the process as according to the lawsuit's opinion, the section 10 has to be raised, rule 10 has to be raised. Rule 10 refers to existing vacancies. And the
anticipated. Any decision on existing
vacancies. And anticipatory.
Just like this.
So far the anticipatory
service law
doesn't come.
Service law. Promotion. Existing vacancies. DPC, existing vacancies. Service law. Promotion. DPC. Existing vacancies. There must be decision of Supreme Court on that. You have that?
Regarding existing vacancy,
Why
we
were state of AP?
1983, alum 3 SCC 284.
It's from Andhra Pradesh. Andhra Pradesh. Must
So let down. Vacancies starts occur prior to amendment of recruitment rules must be filled in accordance with the old rules. Not the amendment rules.
That judgment has been over.
No, existing.
I think there is a line of judgments where this is defined, the recent judgment. It says that it is on the date of DPC, whichever law is applied, you are going to apply that, irrespective whether the vacancies are
before
or after. In that context, that existing vacancy term has been defined.
Now, so far the question of law is concerned, the Lordship is hearing this matter on Article 227. The judgment of the tribunal is the subject matter of dispute and subject matter. Correctness of the judgment of the tribunal is now Your Lordship is considered. So far the tribunal is a creature of statute and under the Administrative Tribunal Act. That's some provision. We'll just refer to that, nothing to elaborate. But so far as this process of promotion as contemplated under the rule, as Your Lordship rightly said, the rule doesn't provide anything with regard to the requisition. But fact remains the date when way back in 2011, this restructuring was made just before that. Now the part process has begun. Also look to that annexure, which I have given annexure C/3. My read application where I have intervened is 25911 of 2014. Second survival.
Why this matter is pending for so long?
State petition that not anything like that.
Yes.
If you also look to that annexure C/3 of the case number 15805 of 2015.
Yeah.
So this is a letter addressed by the Government of Orissa Finance Department to Secretary of all Department of Government, all heads of the department, all collectors. So appointment of OTA and S. President come to the next. Sir, Madam, I'm directed to say that government have decided to appoint some officers to the cadre of Orissa Accessible Account Service OTA and S class 2 by selection under clause C, rule 4 of Orissa Accessible Accounts Service 211 from amongst the government officers. Let's keep over. Next page, once we come to next page, para 2. Since the vacancy to be filled up by selection to the service are very limited.
Only willing candidates should be given.
Sir. Then, sir, para 3, it also must meticulously be covered in the recommendation of the persons nominated so and so. First, we just skip over. Score no candidates should be nominated against the CBI Vigilance Department so and so.
Who are facing the proceeding.
Why I am saying so? Because we look to 9, the recommendations along with the attested copy of the CCR are required service particulars properly filled in respect of such nominated candidates which the finance department by a particular date. So this is the basis on which the process was begun. The Lordship have already seen that Rule 4. Rule 4 refers to 3 categories.
Yes, we have said that. 50,
50%.
Yeah.
So for the project, I am representing the intervener, their selection. Like 20%. Now the question
Mr. Mishra's clients are also 20%.
So now the question is, the date when the DPC was held, it was not on that day itself, all these records and all these words were produced. They have to be called for by the authority to be placed before the DPC much prior to that. That is why then you also kindly see Rule 10 must be read with other provision of Rule 4 so that you also can come to the conclusion that some process has to begin. Some process has to begin by Lord. Rule 10(2) also provides there are 3 other rules are required to be satisfied. That is the Orissa reservation of vacancy and post and syndicals are verified. The Orissa Civil Service Zone of Constitution for Promotion Rule. The Orissa Civil Service Criteria Promotion Rule 1992. The Orissa Service Criteria for Selection for Appointment and Interim Promotion. If you also will see one of those rules, I was looking to that. If you also look to Orissa Civil Service Zone of Consideration for Promotion Rule 1998, rule.
Yes,
I can prepare a note for you also.
Anyway, just argue that. We are recording everything in our mind. Yeah.
So, zone of consideration of Rule 3 provides that except in cases where the provision of Orissa reservation vacancy post of sufficient for civilians 1975 and the rules where thereafter are applicable, in every case of promotion made by way of selection to any civil service or post of the state, zone of consideration and to prescribe in the relevant recruitment rule. Such zone of considerations have been 3 times the estimated number of vacancies. That means the vacancy as was available on that date.
1:3.
Sir. So therefore, the vacancy as was available in January 2012, when this is on date is the date is the January 39, 2012. Yes. So that on that day, the vacancy existed. Whatever vacancy was available, this was the vacancy available. In terms of these rules, they have submitted the proposal and all the districts.
Let us see the resolution which provided for enhancement of the cadre strength. What is the reason the government has given? Yes. Did it say that there is urgent need of working hands and therefore we will do that?
We can see.
Just give the reasoning why that resolution is made.
Nothing is there. Only this is that. The Rashmi already read. In pursuance of the Finance Department resolution dated 28/2009, read with Finance Department resolution dated 17/7/2009, cadre strength of Orissa Taxation and Account Service was 345. In the 14th meeting of the Cabinet held on 17/5/2011, the cadre strength was increased from 345 to 563. Now, in pursuance of the decision of the Cabinet in the 23rd meeting held on 18/6/2012, the cadre strength of Orissa Taxation and Account Service has been increased from 562 to 753 as per the schedule annex. That's all.
What the cabinet? Any observations of the cabinet?
No, sir, that I don't have.
That is not part of the record, my lord, so it's not there. Because the requisition must have gone to the cabinet for a decision,
Yes,
and that must have given the reason.
Yes.
That must find place in the cabinet proceeding.
No, cabinet proceedings we cannot call because there is a constitutional part. There is an article. Can anybody figure out that article?
Proceeding, you are not
The court shall not call the cabinet decision.
The proposals that was placed by the finance department for enhancement of the cadre, that must be there. You needn't go into that. The proposal
was the Harvard Journal, you must have.
The finance department must have given a proposal for enhancement of cadre.
That's natural. Otherwise, they would not do it.
That proposal would be available with the finance department.
No, we cannot call it because there is an article in the constitution.
Yes.
Ask the court from calling all that.
Cabinet proceeding, your lordship cannot call for. But the finance department proposal can be called for.
Finance department proposal has been referred to in that letter. That proposal which was submitted. So all this cumulative effect is the process was begun in the month of January 2012. At that time, the vacancy as was existing is 563, not beyond that. Then you also kindly see so why I.
In other words, existing vacancy means 563.
Right, sir. That was
at the stage of litigation, which you mentioned the adoption.
Sir, sorry.
Yes, is consistent with the you can just to do that with full form. Yes. 74. Article 74 says court cannot call her. How it is worded? Yes.
Sir. Then you actually see the other rule, which has been also rule 10.2 refers to Orissa Civil Service criteria for selection and appointment, including promotion rules 2018 D.
What does it say?
Sir, rule 4, yes. Promotion, the departmental promotion committee or the selection.
No, you can read it. Sir, if we want to see the video,
sir, I can quote it and I can give it my notes. The departmental promotion committee or the selection board or the selection committee, as the case may be, for the purpose of appointment by selection or promotion to any service public post.
So 30 plus 20, both are covered. 30%.
Yes, sir. Again, I'm reading. Get it better. Yes. Rule 4, page 198. The departmental promotion committee or the selection board or the selection committee, as the case may be, for the purpose of appointment by selection or promotion to any service of the post, shall prepare a list of persons of the feeder grade of that service of the post who are considered by them to be suitable for such appointment. So therefore, if you also look to this 4.1, that means these processes are required to be taken into consideration. Yes.
No, what is it? It says how the
that's why I'm saying. So if you also look to rule 9 and 10, rule 9 and 10 of that rule, so that has to be prepared in terms of these promotion rules, which is also a requirement of 10.2. 10 to this Orissa Civil Service Criteria and Selection of Appointment 2003 has to be resorted to. So that therefore the existing vacancy, how it will be filled up, the manner in which, because we are now concerned, the process when it was began. So if it will be, this rule will be invoked, then certainly will not, that must be prior to the DPC. If I am correct, Lord, the vacancy are required to be what are number of vacancies? They must have to find out.
Correct.
What are the call for the nominations, who are the eligible person, who are coming within the zone of consideration. These are the requirement prior to the DPC.
Correct.
Sir.
But question is, The rule says,
Sir,
as on the DPC
Sir,
met.
Sir, when your lordship is dealing with the rule was in the context of the provisions for which it is applied. The rule also says that you have to do in accordance with these rules. 10.2 says, and they have done also. 10.2, you have to look again to that provision, 10.2.
In this,
Yes, sir, say
what
that
is the page number?
Page number is no,
My
that
lord,
is
that,
Rule not there.
that is there. Page 39, my lord. Page 44.
Compilation also it is.
that is there.
Compulsion page 44.
Compilation is
Yes, sir.
Compulsion page 23.
Page 20.
Writ petition, page 44, your lordship.
No, compilation.
20.
I will also say what
Yes, sir.
it is. 19.
Yes, procedure for selection by the board. Because you have already read time and again. 2. The board while considering. Sorry.
The board shall meet, it begins that way.
Yes, sir. The board shall meet at least
Once in a year, preferably in the month of January, to prepare a list of officers
suitable
for appointment to the next higher grade,
taking into account the existing vacancies
vacancy.
and the anticipated vacancy for the year. Then 2, the board while considering the promotion cases of suitable officers, public employees, and preparation of the list shall follow the provisions of A, the Orissa reservation,
The A, B, C, D.
A, B, C, D. Now I read C and D.
You have
Read that rule 4 of Orissa civil service criteria.
no question is,
Yes, sir.
existing vacancies means what?
Sir,
Keep that in mind.
that's right, your worship, sir.
Then you build your argument.
Sir.
That becomes easy.
Sir. No, I'll definitely find out. I tried to find out. I could not find out exactly this point. So for those existing with my learned friends, so that is totally different. That has nothing to do with context.
The
The vacancies.
Rangaya's case.
Yes. So now we have to see that in the context of promotion, and by the DPC, particularly if that is a provision in the rule that existing vacancies, whether the process is required to be begun prior to that, or because it is existing, you must be confined to that provision only, which make the entire provision redundant, according to my respective submission.
Mishra wants to add something.
Existing vacancies as on the date of the meeting or existing vacancies as on the date of the process beginning. This is the question.
Yes.
That is the question.
That is also
Existing vacancies as on the date of the meeting of the board or
Because
the process beginning.
the board shall meet once in a year,
That's it.
in the month of January preferably, to prepare list of officers of suitable
No appointment.
for appointment to the next higher grader
Taking into
grade, taking into account the existing vacancies. Means what? Existing vacancies means a prima facie. Vacancies that exist when the board met. It may be a day before, eve of the meeting. It cannot go 1 year back.
That is the point. Because the entire consideration for starting initiating the process of selection is
Let us let us dissect this section. One is board is the recommending authority. Board is constituted by the government. It is the recommending authority. It is not the appointing authority. It holds the meetings. And that it has to do at least once in a year. And that should be preferably in January. What for? For ascertaining the existing vacancies, candidates suitable for promotion to the next grade for the existing vacancies or contemplated, or what is that? They have used anticipated vacancies. Therefore, what we have to, wherever, that was the argument of Madam Popping, wherever lawmaker intends that the DPC begins on a particular point of time, and the time scale, there is indication. What is that? There are some rules made by the very same state government not different government. Rule maker is the same. Rule maker, wherever he wants something to be done this way, he has said, he has kept the requisition point as a milestone. Because two sets of rules, Madam Pami referred, that the requisition is not internalized in Rule 10(1). This is what they have argued.
So
That you have to.
Yes, may I just?
Yeah.
Just see.
1 second, sir. 1 second. I'll come to you. You are going to traveling to 10(2).
Sir.
10(2) is the next stage. It is an operational.
Right, sir.
It's an operational stage.
Yes.
But what the board first has to do is, because the expressions existing vacancies and anticipated vacancies also, many are superannuating. Minimum, some of them might have applied for a resignation. Some might have been removed.
Expected vacancy is not.
Yeah. Therefore, the objective is existing and those which have been accruing also. The idea of the lawmaker is not to draw the line between the existing vacancies and future vacancies. Lawmaker says, you do something for the future vacancies also. If that is the intent, then what is the jurisprudential justification for excluding the vacancies that come because of the enhancement of the cadre strength? Because law is saying, even future vacancies, you have to wait for that. If that is so, these are between existing vacancies and future vacancies. The vacancies that arise eventually because of creation, enhancement of this cadre strength, that will fit into these two extremes. This is one possible argument. Otherwise, it would have said, it would have kept quiet saying that existing vacancies. Rest of the vacancies, do not worry, because they have not yet arisen.
That existing vacancy,
Two expressions. Two expressions.
Relate back to the date when the process of that was began. The process of started.
Are they not future vacancies?
Sir,
are they not? They are better. They are more than anticipated. In anticipation, there is some element of contingency.
Eventually, yes.
Eventually, date, retirement,
so etc., etc. But here there is no
Definitely.
It is so certain. Posts are created. Eventually, vacancies are there. You mean to say they should be excluded?
Sir, my respect to submission is that vacancies are there, but the vacancies for those vacancies already process begun. Much prior to that, because that is bound to be commenced prior to that. Otherwise, the DPC could not have considered all these.
But then can it be taken that the process which has been undertaken to enable the DPC to consider is part of the DPC?
No,
that is an official exercise.
That facilitate consider. What year is it?
First thing, DPC, when it meets first day, after sipping the tea and saying welcome to the members, the first thing they have to do is, if they should ask its secretary, convener, how many vacancies as on this day? How many vacancies are going to accrue?
That's it.
In February, March, April, May, June, July.
Yeah.
That they have to take. The vacancies that are accruing, see, I tell you one more thing. This anticipated vacancies cannot be beyond 31 December.
Sir, that is exactly what
That's the definition.
That is so.
There's a definition clause. What is the meaning of year?
Yes. Look to 10 again.
From 1st January to 31st of December.
The last line.
Calendar year only.
Only 3 things can I show, Melody? 3 things. Please, I'm sorry.
No, we can.
Let me kindly see. 10(1) says existing vacancies and anticipating vacancies for the year. The year.
Correct.
Now, year has been defined at 2
calendar year.
Calendar year.
Correct.
Now, if your lordship sees the proceedings, 2 proceedings have happened. One is in 2022 and the other one 2012 and the other one 13. So my lord may see that heading of that proceeding. At page 64 of that compilation, it is there. It is all saying that for the year 2012.
Correct.
So for the year 2012, the board met and took this decision. So for that calendar year, the board has to see all these vacancy positions.
Correct.
So what fell from my lords is absolutely correct. So whenever they meet, for that year for which they are considering,
correct,
they have to do this exercise.
Yes. But vacancies, the new posts are created
My lords.
in that year only.
June
July.
2012.
Now, the process began in 2011.
There we have problem now.
Yes.
We are on the process, which brother said, all that is preparatory steps. It is all preparatory. The first peon may start bringing the file on my table. There the process does not begin. Process means legal process. Whenever you call it, whether it began or not, there is a duty cast on the board to ascertain in the first meeting itself how many vacancies existing, how many vacancies are going to arise. You mean to say vacancies that are going to arise do not include the vacancies eventually arising because of the creation of posts? That will be too much.
Now, my lords, when the creation happened, prior to that, the process had begun.
There, we are only revolving around. Yes, that's how.
This has to be read in the discretion.
I'm showing one document.
No, we are asking because we have said that way. We are not.
That's
We are only grilling you so that we can get some more mind. You are. That's all.
Sir, we welcome that your lordship must ask the questions, whatever to the extent possible.
Very difficult when your lordship do not interact because you cannot look at the other's face and read his
Suppose
mind.
if we sit like a rock of Gibraltar without giving a piece of our mind to you and disturbing your peace, it will not.
All along that would be concern and what
That's all. It will not be a case of hearing.
Bench thinking. You are thinking about that, you will forget your point. And it is also educative for the bar.
For us at least, for judges, for me. My brother is very good. These seniority matters, he is very superior.
And as far as the rationale behind fixing the date in the month of January, what is that?
Sir, kindly come to page 82 of the brief. Of the application 82 of WPC number.
What you want to say? Just articulate and then we turn the pages.
The interim order was passed. Whatever interim order was passed, that interim order also have seen. Respondent may go ahead with the.
It did not interdict the process
They
at
may
all.
go ahead with the DPC.
Yes, but don't skip a point.
Sir. Then kindly come to page 81.
Yeah,
Sir, that is on 5th May 2012.
correct.
The Government of Orissa Finance Department addressed letter to the Commission on Commercial Tax and others also.
Yeah.
Subject appointment of, so far this appointment is concerned, for the year 2012. Sir, I am directed to say that the meeting of the selection board for promotion to the OT and AS class 2 by way of promotion will be held on 17/5/2012.
Correct. But it was not held.
Sir, on 17/5, I don't know.
No, it was not
Submitted.
It was not held.
So therefore the DPC, so these are the documents which are trying to place with your lordship. These are the process of selection already began. The DPC was required to sit on 17/5. That is before the July 2012, before the enhancement of the vacancies. Even if such a decision has not been taken by the DPC, now that was deferred till the month of December. So can it be said that it enhanced the existing vacancy means the enhanced vacancy includes 700 some odd?
Otherwise, you will be doing injustice to the. You have to manhandle the provision. That we are not that strong.
Yes, sir. It is not a question of manhandling. It is a question.
Kindly see, kindly,
Sir.
just transcend the interest of your client.
Sir.
What is meant by anticipated vacancy? Everybody knows. if you are going to make a provision for anticipated vacancies also, why can't you make the provision for the vacancies they are complete with you pursuant to order of the government?
Sir, anticipated vacancy can be also taken into account while the process began. But the future vacancy which will be created, that was not within the knowledge of the that process. Our entire case is
what is meant by anticipate?
Sir,
See the meaning of the word anticipate.
Anticipatory vacancy means from that year.
What is meant by anticipate?
Retirement.
Correctly understood. These are the vacancy to be occurred on retirement.
Probable. See, there is no certainty. Element in the word anticipate, the elements of certainty are lacking. Even such also should be kept in view by the court is the intent of the lawmaker. But when the very vacancies are available, because the sanction strength is increased, they should not be taken into. Anyway, we have said that.
So our entire.
Shall we go to the next point?
Please. Now, the next point, which I have to kindly see, because the judgment of the tribunal is the subject matter of challenge. The tribunal, what he said, suppose one person had approached the tribunal. In 2013, judgment was delivered in 2014. By the time the judgment was passed, judgment was delivered, the persons, so far the promotion is concerned, in my case, in the second case, twice the promotion have been given. Your worship said least pendant. But the least pendant, certainly, suppose if the petitioner had challenged the recommendation, as your worship rightly said that to please find out the law, if the recommendation has been made, whether they have a right to be included as party or not, that's it. That's the issue. If DPC itself is the subject matter of challenge, DPC we have been recommended, all the cases of the petitioners were so-called the interveners were recommended. You have not depleted them as parties. You proceeded in the original application and subsequently they got promotion. Twice 2 promotions they have got in the meantime. Sir, I found one judgment. Of course, I was also a counsel there.
But your DPC is not more than a select list.
Sure, sir, exactly that is the point. That was the
And
case.
who says persons who figure in the select list do not have indefeasible right to appoint when.
Here is a case I'm trying to impress your worship and trying to persuade your worship. This is a judgment, Orissa Public Service Commission versus Priyam Das of division bench of this court referring to various judgments. There the preliminary examination result was published. They have to appear the main examinations.
Yeah.
But the person, those who are declared to have passed the preliminary examination, they are not made parties before the tribunal. That judgment was challenged. It was said that even if you could have made at least 1 or 2 persons as party as a representative, if you have not included them as parties, the order of the tribunal must go. Is invalid. Now, so look to paragraph 2 paragraph. Paragraph 20.
Where the facts are stated.
Sir, can you also look to paragraph 23?
There are 2 facts.
Facts, sir.
Madam Ratha cannot deny this.
I can deny something. No, but I can deny the non-application to the present case.
Sir, can you also look to paragraph 23? I think that will be around 23, yes. What is the broader issue? I'm not going to that case, Jadav's case, that Poonam, the another judgment in Poonam case, but I also look to this. But hearing the parties and on perusing the documents, including HCNCR, the following issues arise for consideration in this case. Whether selected candidate of the preliminary examination were required to make parties before the Royal Tribunal. Sir, para 24. Coming to issue number 1, let us scan the various amendments and prayer made by the opposite part number 1 in the original application. In paragraph 3 of the original application, opposite part number 1 makes it clear that she challenges the illegal selection made in the preliminary examination 2011 by the OPSC by adopting wrong and illegal marking procedure. And paragraph 6.8 original application, the middle portion, opposite part number 1 clearly about the result of the preliminary examination, Orissa is illegal and void as the OPSC has acted beyond jurisdiction in giving grace mark. That's the key portion. Kindly come to paragraph, conclusion, paragraph 29. Yeah. Even paragraph 29. Even otherwise, as per section 22 of the Administrative Tribunal Act, the learned tribunal, while disposing of a case of or adjudicating a matter, has to be guided by the principle of natural justice. One facet of such principle is that nobody should be condemned on earth. Here, selected candidate 5,823 number have been condemned on earth by setting aside their selection in their absence. For all these reasons, we come to a conclusion that the selected candidates are necessary parties, and the learned tribunal has gone wrong in disposing the matter without insisting on their presence in tune with the principle of natural justice. As held in Prabodh Verma's case, Shukla, the learned tribunal ought not to have proceeded without insisting on the impression of the selected candidate as respondent and at least some of them being made party in a representative capacity, and if the opposite parties for one refused to do so, it would have dismissed the original application for necessary parties.
Did it travel to a fixed court?
No. Sir, after judgment, I will give it because I could not have marked him. The other judgment of the law, division bench. That's not the issue, sir. Yes. J.S. Jadhav case, you also must have known that judgment. Of course, that is a case of termination, but you'll also see the principle which has been decided. Which way? Can you also look to page 583. We have paragraph 31.
Yes.
Can you look to para 31 of the case Jadhav's case? The principle which has been decided, I don't say that case of dismissal or other thing, that is something different. But you see the ratio decided in that case, which has been referred to in this Yamada case also. Para 31. No order can be passed behind the back of a person. Para 31.
That was a case of termination from service.
That is a case of termination, but this is the ratio which has been referred to also in other cases. No order can be passed behind the back of a person adversely affecting him, and such an order, if passed, is liable to be ignored, being not binding on such a party, or the same has been passed in violation of principle of natural justice. The principle enshrined in proviso to order 109 CPC provide that implement of a necessary party is mandatory, and in case of non-joinder of necessary party, the petitioner plaintiff may not be entitled for the relief sought for by him. The litigant has to ensure that necessary party is before the court, be it a plaintiff or defendant, otherwise the proceeding will have to fail. In service jurisprudence, if are unsuccessful,
Some of them should have been.
Yes, sir. That's
The decision what to apex court.
At least in the representative capacity, at least some of them should be made parties. But here in arbitrarily, nobody has been made parties. Then, sir, now you also ask me the question, how we are affected. We are affected, sir, by arbitrarily the decision of the DPC, the proceeding of the DPC was the subject matter of challenge. And during the pendency of the original application, there is no dispute about this. In 2013 and 14, we have been promoted to this purpose and given that in my petition also. You also look to page 109.
Yeah.
Now, once the judgment of the tribunal will be helpfully valid and will be implemented, then certainly we will revert back to the original position. Let's look to that. Because their number is very let's look to page 92, I'm showing. WBC 31996 of 2000.
This is for what contention?
Because so far as our right is
We have noticed this. Go to the next point.
Consequently, we have got the promotion. 2 promotion we have got thereafter. Yeah. That is also admitted factor. Once the tribunal judgment is being implemented, they will be treated to be senior to us, even we are in the selects because of Rule 15. There also Rule 15. Rule 15 says my non-friends are showing to us. Because it was amended. Rule 15. It amended the
Page 20
Page 20.
of that compilation.
Of that compilation, my non-friend has given to us. Page 28. Because Rule 15 has undergone an amendment, yes, in 2011.
Inter se seniority.
Sir. Just I'm reading now. In the said rule, Rule 15 shall be substituted by the following rule. Person was asking whether substituted or inserted. Substituted. Namely, 15, inter se seniority. The inter se seniority of the officers appointed to the service in a particular year shall be in the order in which their names appear, the list furnished by the Commission, provided that the inter se seniority of officers appointed by promotion under Clause B of Rule 4 in a year shall be fixed on the basis of their length of service in the feeder grade and shall en bloc be senior to those appointed by selection under Clause C of Rule 4 in that year, provided that officers appointed by selection under Clause C of
20%.
Yes, sir.
20%.
20%. In a year shall be en bloc be senior to those appointed by direct recruitment under Clause A of Rule 4 in that year.
Appointed by promotion it is.
Yes.
Second proviso is
Yes.
by promotion.
By promotion. Second proviso by promotion. Sorry, I'm reading third.
That
Third. Provided further the officers.
No, only 2 proviso. No.
2 proviso. Second proviso. I'm reading the second proviso.
That applies to you.
Yes.
Not the first one.
The first one
is direct recruitment.
Yes. Provided that the inter se seniority of officer appointed by promotion, under Clause B of Rule 4 in a year shall be fixed on the basis of the length of service in the feeder grade and shall en bloc be senior to those appointed by selection. So we are by selection under Clause C of Rule 4 of that year.
Which one you are reading? You are amended.
First proviso also.
The one which Mr. Mishra has given may not be amended.
Well, it's page 49.
Page 28.
Yes, sir. Compilation page 28.
And this is amendment.
Yes, sir. Again, I'm reading. Justice, thank you.
Yes.
May I read?
Yes.
In the said rule, Rule 15 shall be substituted by the following, namely 15, inter se seniority. The inter se seniority of the officer appointed to the service in a particular year shall be in the order in which their names appear, the list furnished by the Commission.
Or in the select list.
Yes. Provided that the inter se seniority of officers appointed by promotion under Clause B of Rule 4 in a year shall be fixed on the basis of their length of service in the feeder grade and shall en bloc be senior to those appointed by selection under Clause C of Rule 4 in that year. That means the promotion is the first.
30% and 20%. 30% will be above 20%. Then
So
the second proviso.
Second proviso. Provided further that officers appointed by selection under Clause C of Rule 4 in a year,
they will be above direct recruitment. That is above 50%.
Right.
That's all.
So my entire gamut for my submission before RCP is that once the order of the tribunal is sustained, then obviously we have to be reverted back and they will be treated to be senior, and therefore we are adversely affected on the date when the DPC was held and the recommended was held. And that is a violation of this rule.
As on the date the DPC took place, you were not appointed at all.
But recommendation was made.
Only recommendation was made.
That is why that favor the judgment I assume. But during the pendency of that original application, appointment has been made, OPSC has OPSC in consultation with OPSC appointment has been made, and promotion has been given. And no amendment has been made. No amendment, and all the records, that is the specific case of the
But
state.
generally, whether a particular person is a proper party or necessary party is to be decided as on the day the litigation is instituted.
Sir, that also.
Because we do not know.
No, Your Lordship also, Order 110, Order 110,
That's what.
Lordship knows that even during the pendency of the suit, suppose something happened, subsequent events occur, that can be brought to the notice because the judgment, ultimately the judgment, they have to suffer. I saw that judgment, but sorry,
No, 1958 Supreme Court.
Sir, Your Lordship,
AR 1958 SC. Take out that.
Sir, that part is concerned.
Rajia Begum versus Shahnaz Begum.
Yes, sir, I know that judgment, but I again appellate that.
Order 1 Rule 10
Sir.
is impediment of
Parties. On the day of starting of the suit.
To the suit.
Sure, sir. But the subsequent events occurred during the pendency of the suit are also, they are also necessary parties because of the make it. They are also necessary parties in which circumstances that you also will include. But my first submission is, even if the Lordship will go on the basis of that judgment of 1958 Supreme Court, that the DPC which was held, the recommendation was made in our favor.
That's true.
That recommendation also can keep it in mind. And the names of these interveners are also very much there in the DPC itself. So they knowing fully well they have not made us party. And so far the promotion or other things are concerned, our appointment, those are available before the tribunal. You know, the counter, the state has specifically said these records are very much available in the file of the tribunal. But the tribunal did not take any steps to implement them as parties. Sir, this is one. Then, sir, so far as the tribunal's judgment is concerned, second sub-item, this in the Rashmi Rekha Tripaঠি's case, they have implemented the judgment passed in the other case, that my Lord Senior Prime Minister, first sub-item, that Vibhu Mishra's case. So, Vibhu Mishra's case, what the tribunal has said, that it will be applicable to all candidates who are similarly situated. My respectful submission, the tribunal has no jurisdiction. Your Lordship, while exercising the power on Article 226, certainly the Lordship can do it. But your Lordship is examining under Article 227 the correctness of the judgment of the tribunal. And tribunal is expected to act within the four corners of the statute. That means Tribunal's Act. Your Lordship look to Tribunal's Act.
Section 13, 14.
Yes, sir. 15 is the
15, 13, 14, 15. Wait, that the conspectus of these provisions in L. Chandra Kumar versus North India, 97 Supreme Court.
That's why they take the order. They're there with the High Court.
Or with the, except virus of the provisions of statute. Statute, no, rules.
Yes.
They cannot. That
Sampath Kumar, L. Chandra Kumar.
Yes. In that case, what has the Supreme Court said? All powers are available to tribunal. That does not mean they can go beyond the statutory provisions of the Tribunal's Act.
Correct. Except that they can go everywhere.
Yes.
Because they cannot go statutory because under that statute it has been constituted.
Yes, sir. Piece of that act cannot be challenged. They are bound by that act. That is what the Chandra Kumar case has it has been said. Let's look to page 8. I have made a compilation definition. You think it then. Since your Lordship is discussing this matter in detail, so we are.
Yes, that helps.
We should at least try to persuade your Lordship. Page 9. Lordship, look to service matters. Section 3 PQ. Q. Service matters. Let's get it.
In 9. Yes.
Page 9.
Yes.
Q. Service matters
in relation to a person.
In relation to a person means all matter relating to the condition of his service in connection with the affairs of the Indian or of any state or in local or other authority within the territory of India or under the control of the government of India or as the case may be or any corporation owned or controlled by the government.
Remuneration, that you can employer there. Please skip off that. Come to Roman 1, 2, 3, 4.
15, sir. Then, sir, that's why kindly come to 15. That power of the tribunal. Jurisdiction, power and authority of the state administrative tribunal. B, you also look to B. All service matter concerning a person, not being a person referred to in clause C of this subsection, or a member, person, or civilian in clause B of subsection 1 of section 14, appointed to any civil service of the state or any civil post of the state and pertaining to the service of such persons in connection with the affairs of the state or any local authority under the control of the state government or any corporation owned or controlled by the state government. So my respectful submission is the jurisdiction of section 15, which confers power on the tribunal to adjudicate a matter to a person who had approached this tribunal relating to service condition or service matters. So service matters are defined is to a person. Here the tribunal what has directed the operative portion of the judgment in the first case in the interim judgment is also applicable to all 58. First we look to that interim judgment, that is the operative portion.
But a person includes, singular includes plural under the General Process Act.
Person means those who have already approached the tribunal, those who have already come to the tribunal. It cannot be beyond the person, those who are not approached the tribunal. That is what my submission is.
Mr. Mishra also said,
right.
You cannot, tribunal has no authority to expand the relief to those who are not before the tribunal. That's in submission.
So the tribunal judgment of page 94 in WPC 20325 of 2020, this is the direction. In view of the above, the respondent authority...
All similar persons also included. I did mean for direction for consideration we would have understood.
Yes.
Since it's a direction in species,
yes, right.
that could not have been done.
That is exactly what is said.
Next point. Next point.
Then my last submission is this. Here also kindly see that again from it. Sir, already Mr. Mishra has argued that point. So far, the suppression of the facts is concerned.
Yes.
We had if you also look to the original application filed by the respondent number 1 in
those 2 pages. 2 pages.
2 pages. But if you also look to that approach before the tribunal, what was the specific case of before the tribunal? Also look to that. That is 6.1 paragraph.
A, B, C, 3 prayers are there.
Sir,
A is for quashment of the DPC proceeding. B for reviewing the promotions granted.
Sir, what is your page 31? What is the entire case in the before the tribunal? Page 31 of WPC 20325 of 2014. The first case where Mr. Mahanti was appearing. The first case. Page 31.
Yes.
Sir, the compilation
direct response to convene DPC for promotion.
Page 31, I'm reading.
No, page 10 of the compilation.
Your compilation?
Yes, you have page. No, yes. You have to look to that because you also be better convenient to refer to that. Page 10. Para 6. Sorry.
To direct.
Sir, to that the next paragraph. 6.12. That the Honorable Tribunal by order dated 2012-2012 disposed of the matter in the following direction. Considering oh yes, sir.
There is 6.11.
Yes. 6.11.1 to direct the respondent to convene DPC for promotion to the cadre of Orissa Taxation Account Service in accordance with Rule 10. To direct the respondent 1 to consider the case of the applicant for promotion to cadre of Orissa Taxation Account Service. 3. To pass such other order as would be deemed fit and proper. Then Tribunal on 2012-2012 passed this order which has been quoted. Considering submission made by non-counsel, the both parties respondent who is directed to collect CCR, PAR of the applicant from his present place of posting and send the same as practicable, preferable before the date of meeting of the DPC. Respondent also is directed that after receiving CCR and PAR, the applicant shall place all the records which are required for this one. So first is keep over. Then you also kindly come to, you also kindly see that have they said anywhere, and the prayer you also have already seen, this was the, then they said that para 6.13, this was the judgment, para 6.13. This is the entire original application. Without taking into account the order of this Honorable Tribunal on 22/12/2012, the selection board meeting 22/12/2012 to consider the case of eligible officer for filling of 101 posts, 84 CTOs and 74 accounts in Orissa Taxation and Account Service Class 2 for the year 2012 by way of promotion from amongst commercial tax officer and treasury. The selection board considered the case of 215 eligible officers from treasury account, taking into account the cadre state as 563. What I am trying to impress your worship, this was the entire approach that the petitioner, who are the respondent of 1 year, and the tribunal, and my friend has already read that order of the tribunal. The tribunal has also quoted this, but the order, the DPC, which was subject matter of challenge, where their cases have been considered, thus page has been omitted. Had it been placed before the tribunal, tribunal would have considered that, would have taken into consideration that this 563, whether they are eligible or not. They want to say now, because that tribunal will also look to that paragraph.
That should be page number.
पेज जो
begins.
ये जो पेज था वो इंसर्ट करके देना
Page.
नहीं जो टाइप का इंसर्ट लॉक करके देखो उसे देखा वो टाइप इंसर्ट लॉक करके चलते तर इफेक्ट तक you also look to page 64.
64 is the complete one.
64 is the complete one, but the which they have challenged, that is at page. Yes, page 50. Page 50.
Page 50.
Of your compilation. Yeah, same. That was the subject matter of the report to travel. That is a part of the OA's improved order.
Annexure 7.
Annexure 7, it was in the way. That is at page 50. Sorry.
That would be the yellow flag mark.
Correct.
Mark for convenience.
Correct.
Annexure 7.
Yes, Annexure 7.
Yeah. This is the DPC proceeding.
DPC proceeding, which was the subject matter of challenge. This was challenge. So this page 50, you also look to that after page 1, 4. That means 2 pages are missing. That 2 pages we have given, Mr. Mishra also has given, that is at page 64.
He said, what turns out by producing those?
That they refer to that paragraph 2 in the meantime, the Honorable Tribunal, as well as the Honorable OAT Katak, have filed the following ACTOs as indicated against each other. The names are the Vibhu Prasad Mishra is there. By taking into account the order of the OAT, the selection board duly considered the name of the above 4 person as they have got adequate CCR required for promotion. As such, the OAT have been fully compliant in accordance with that. Means they have taken into consideration. My respectful submission is they have taken into consideration the so far as these orders are concerned. Their entire case before the tribunal was the tribunal are directed to consider their case not against 763. What that is nowhere it has been specified in the original application, and the prayer, as you also have said, that prayer is 1, 2, 3. This one. And the order which was the subject matter of challenge, they have never disclosed. They have suppressed the fact, this paragraph page 2 and 3, that has been taken into consideration. That is for the subject matter consideration. And I have already prepared a note. Prepared a note. I'll give to that note which along with it.
1 minute, since suppression is alleged against me. Lord, what is the case about page 32 of the date petition? Kindly have.
Sir, Sir, in Rasmireka Tripathi, where I'm appearing that is the second summary. In fact,
the last point in your note.
Yes, sir. In that case, what has happened? She has approached the tribunal, suppressing the fact that she has already got promotion. In the meantime, before she approached the tribunal, she had already got the promotion, but she has not disclosed before the tribunal that she has got the promotion. Had she approached the tribunal with the clean hand that she had already got the promotion, the position would have been something different.
Sarla. Only one thing I want to get. What was the scope of that writ application? Your Lordship, paragraph 613 has been placed. But paragraph 614,
6.114.
6.14 and 6.15 is the case, my lord, that the action of the selecting to take the illegal express admitted complete as would be evident from the selection proceedings, some officers who are not available, their case has been deported. Though the Honorable Tribunal specifically has directed to convene the meeting of the only after receipt of the application in under Rule 10, it is further submitted. The cadre strength is 753. As your lordship got that time?
Yes. But taking the cadre strength as 563.
Selection has been done in complete contravention of the as well as the statutory provision. If the cadre strength as 750 would have been taken in then as against 30% promotional quota, then this would have been the case, I would have been considered. That was the case before the tribunal.
But what was your prayer before the tribunal?
Prayer, my lord, your lordship kindly see. Prayer was to take revise the cadre, to take into account the 753 as the revised strength of the cadre.
Because to your prayer?
Your lordship will kindly look at the OA, OA has been annexed,
Taking into account the cadre strength as 753.
Yes, my lord.
753.
My lord. So, rest of the things, we are only going round and round.
Well,
so, and all other things,
I'll cover
covered about that case cited by my learned friend Mr. Rautrai, so where he says that the preliminary examinations result was challenged and the selected candidates were not
made
parties. This is a case where appointments was made subsequently and DPC proceedings are not available to everybody unless you apply under RTI or something and before the publication of the select list by the OPSC, whether they would have given or not is a debatable thing. I have come immediately after the DPC in the month of February.
No, they are saying that this is what they are saying and we are telling you what they have said. They say you knew all those who were recommended by the DPC.
How do I know? That is
I'll answer that, Your Lordship. I'll answer that. Your Lordships will kindly see.
And who will be appointed? How many OPSC will concur? Whether the government will proceed to recommend the names or not, nobody knows.
Your
There are so many.
Admittedly, Mr. Mishra and Mr. Rautrai are representing people who fall in that 20%. They are that selection promoting people, and we are promotion people. If 30%. I have to use that, yes, 30%. Now, Your Lordships, the DPC which was sought to be reviewed was only confined to the promotees.
Not the 20%.
Yes, Your Lordships, only that 30% zone. Rule 10 is referable only to that 30%. Their DPC or whatever their selection board.
So they will not be affected.
What I mean to say is, even if that DPC proceeding had been made public, their name would not have figured on the date of me filing the OA.
Because they were not in the
yes, because their selection process or their
by another DPC.
Yes, Your Lordship, which happened on 28/2/2013, much after my filing. And
yours was February 2013. 13. No.
12 February 2013. 13.
Yes.
DPC happened on 28/2/2013, means the last day of February. And their list came out on 18/5/2013.
Select list.
Their select list.
The recommendation.
Yes, Your Lordships. So, Your Lordships, on the date of OA, they were not there. So the question is, why are we really not challenging that DPC? Because the people who got in that DPC were admittedly senior to us.
So their seniority you are not upsetting at all.
Your Lordships, may I?
No, you're asking.
Yes, Your Lordships. There's no doubt about it. That moment, the zone.
Madam Pami is saying that your apple cart will not be disturbed at all. Even otherwise, you will not be disturbed.
I'm saying something else. I'm saying, let me explain.
I
am
can
trying to
just
say
rephrase what I had said. The prayer in the OA was simply to consider them for promotion.
No, that's all right. Now, assuming as it is
If you
now.
date it back to 2012, then all of us who have been appointed in the meanwhile go for a toss without we being heard. So the tribunal, that's why one of our specific contention is the tribunal has traveled beyond the OA.
No, not only that. This DPC is confined to 30%.
Yes.
Yes.
How you are concerned with that? It does not relate to 20% at all.
They're not. First of all, Madam Pami's clients were not there before the tribunal. It was only 1%.
1% is also 30%.
30%.
Yes.
Now, if the order of the tribunal is implemented, then people who have been promoted prior to them, now they were all promoted in 2014. 2013 appointees now will be junior, and Rule 15 will be completely rewritten because 2014 appointees will now be ahead of us because of the direction of the tribunal that give benefits from 22/12/2012. That direction was beyond the prayer of the OA. The tribunal has stretched itself as if it was handling a PIL.
May I? No, Your Lordships. May I? What was the case of the petitioner then? The petitioner's case was this, that the cadre strength had increased to 700 something. So when the cadre strength increases, so also the number of posts in that 30% quota increases.
In 20% also it
increases, Your Lordships. So anyway, whoever is in the 30% quota will always remain senior to you. In fact, Your Lordships.
Because of the rule position.
Yes, but the
that
question
is for C.
Yes,
the proviso, second proviso. Second proviso.
No, Your Lordships, yes. Rule 15, which fixes the inter se seniority.
That's all.
But Your Lordship, the question is, here the problem is much prior to this inter se seniority happened. Inter se seniority only happens on the date of after appointment. But the problem that we are addressing before the tribunal was, what are you doing the mistake in your DPC itself? So you are debarring people who as such would be senior but could not become senior because of your fault in conducting the DPC.
Or lesser number of...
Yes, Your Lordship. One person may go there, but ultimately what is his prayer? What is the foundation thing he is saying?
But what is the order?
No, Your Lordship, I'll come to that. What is the foundation thing he is saying? The foundation thing he is saying that you have squeezed the number of posts. Kindly review it by taking the actual number of posts. And when this happened, the natural benefit is I would be considered along with those people. And if I fit in by the virtue of my CCR, I get it from that date.
But that is not the order.
Your Lordships.
Order is for 753.
Yes, Your Lordships. 753. That's what I'm saying. 753.
That includes.
Yes, 753. Unless that 753 is taken into consideration, nothing can percolate to this single petitioner also, because his case is what? His case is this, that instead of considering the strength as 756, you did it to 563. Now, Your Lordships, I'll just read a line from that DPC proceeding, which they say that I have actually not filed. Had I filed, I actually would have succeeded better. In that very DPC proceeding,
2 pages.
Yes, Your Lordships, DPC is saying to itself, yes, the cadre strength is 756, yet I will not take it. I hope they had placed it. Your Lordships, there is a affidavit which was filed by the opposite party, which I will just read a line from that para 3 of the DPC. The total number of sanctioned posts of OTAC cadre has been revised from 563 to 753 by
DPC knew
it on 6/7/2012. However, the present DPC was contemplated for the year 2012. So when it says it is contemplated for the year 2012,
obviously it includes these, Your Lordships.
Your Lordships, my whole thing is Where did this DPC have any kind of discretion to go away from Rule 10?
So all vacancies, including the enhanced vacancies, ought to have been considered.
Yes, it was not to them. They still chose not to implement Rule 10. Now, second argument, which Mr. Mishra made.
Have they given any reason for that?
They said, however, the present DPC was contemplated for the year 2012 by calling CCRs in the month of January 2012.
In January, these vacancies were not available. Is there one?
Because you called all the CCR, the same thing, that all the exercises which have happened prior to meeting of the DPC, which statutorily is not recognized under the rules, is our contention. Now, Your Lordships, I would say second thing is, a lot was said on the discretion. The reliance authority judgment, which I have given Your Lordships in a small compilation. Now, Your Lordship, the strange part of this judgment is, it was it explains discretion from para 26 onwards.
The discretion in the realm of service law.
No, Your Lordship, discretion, it explains the administrative law also. It says,
perhaps it refers to Halsbury's particular, that discretion means according to rules of reason and justice, not whimsical.
Discernment. It's a power of discernment where, keeping relevant criteria into consideration, you would do what you would do. So discretion is, suppose a discretion is available to you also, even if I say it is not under Rule 10.
Paragraph?
Your Lordship, it describes after paragraph 12 onwards the whole idea of discretion. I'll summarize it, Your Lordships. May I read para 35 that summarizes most of the things?
Yes.
The word discretion connotes necessarily an act of judicial character, and as used with reference to discretion exercised judicially, it implies absence of hard and fast rule. It requires an actual exercise of judgment and a consideration of facts and circumstances which are necessary to make a sound, fair determination, and a knowledge of the facts which discretion may properly operate. Knowledge of the fact. They had the knowledge of the fact.
No, but this discretion, which Ramnath Iyer's discretion, which you are now reading, is about discretion of the court.
Yeah,
not the authority.
It also applied in the administrative law field also, Your Lordship. In fact, it was a case of tender only, Your Lordship. It was a case of tender only. Discretion, Your Lordship, discretion does not empower a man to do what he likes, merely he is minded to do so.
Kindly come to last unnumbered paragraph, subparagraph in para 35.
The last
discretion
one
means
when it is said that something is to be done within the discretion of authority, that something is to be done according to rules of reason, justice, not according to private opinion, according to law and not humor. It is not. It is to be not arbitrary, vague, and fanciful, but legal and regular. Yes, Your Lordship. I'll pick up my argument to the next level. From here. Your Lordship, look at next page.
Benjamin Nathan Cardozo, in his On the Nature of Judicial Process.
Yes, beautiful book.
He says, discretion means in a given fact matrix, there are competing principles on which you have to take a decision. Choosing one of the principles is discretion.
Yes, I agree. But I say, Rule 10 did not give you discretion.
There was no discretion at
There
all.
was no discretion at all.
All vacancies of that year,
Yes.
when they meet, they should ascertain.
Yes.
Vacancies that are going to arise also, they should ascertain.
Yes.
So that is the only parameter.
Yes, Your Lordship. And I would also say, if you look at Rule 10 once more, Rule 10. Very good. Now, Your Lordship, Rule 10. The board shall meet at least once in a year, preferably.
In January.
Preferably.
Preferably is an adjective
Yes.
to the month of January.
Only. So it is not that it is compulsory to sit in the month of January.
That's right.
But whenever it sits, the first act it will do is to determine the number of posts. And it did. The first line of the DPC says 756 posts. But it forgot the implication of Rule 10. And yes, it took into consideration all those facts happening prior to its meeting, which do not have any statutory recognition. That is its fault, Your Lordships. Second, Your Lordships, an argument was made that if I read this way, it violates this rule. Now, Your Lordships, Rule 4 only talks about the source of recruitment. That is, one is direct recruitment, you can get people. From promotion, 30%, 20%. Yes. It doesn't say that all of them need to happen in the same year. It doesn't say so. These kind of provisions that needs to happen in the same year is found in central government services under DOPT. With rota quota system is there. Not here. Here the en bloc system. So here the inter-se seniority is determined to two things. Whoever joins when, if the years are different on the date of joining, if the years are same, it is anyways predefined. So therefore, Your Lordships, their position where they are today in this particular cadre is because an injustice was done to us or a violation of the rule has happened. So they are in their position of seniority because of a violation of Rule 10, because of the zone of consideration of number of posts under that 30% did not get considered. Now, in any ways, all of us now have been heard on the point of Rule 10's application. So, Your Lordships, I think non-joined of party should not be such an issue. Anyways, on the date of filing over they are not there. They came into scene, if they at all came, some 5-6 months later. With that, Your Lordships, I shall submit. Of course, I have given two more judgments.
In that DPC, who were recommended were not their clients.
No, Your Lordships. Their DPC was totally different. It happened on 28-2. Because Your Lordships, why? The reason being, they are considered on different parameters. Rule 7 says their parameters. They have to give a departmental exam.
Mr. Mishra,
these
your
outstanding
clients were
inherited.
not those who were recommended in that DPC.
That is correct. But what I submitted a few moments back, the order of the tribunal went beyond the prayers in the OA. They set aside 2022 and said that the applicant, only one person ahead of us is okay. En bloc, my sister's clients, if they en bloc march ahead of us, then our entire promotional exercise is set to naught without us being made parties.
No, even that may not be correct. Only seniority may be affected.
Yes.
But promotion as such is retained by the tribunal.
Promotion would, but then our seniority would be taken away without us being made parties.
That is all right.
So that was not the prayer in the OA also.
No, this is a consequential thing, maybe an answer.
But the tribunal went beyond the basic prayer in the OA. And that prompts us to...
No, your questioning. You should have been implemented may not be correct at all. We are giving a piece of our mind to you now, so that you will be able to answer. What Madam Pami says here, you were not the recommendee. Then who should be made the party?
That's why
they are not before the court.
That's why I submitted in the counter. The state also didn't take the plea of non-joinder.
They took, but not urgent.
They didn't take.
No, in the writ petition.
Then the writ petition,
but before the tribunal, they did not take. Rightly, they did not.
Yes, because there was no prayer.
Yes.
But the mistake is not of Vishnu Mishra, the single applicant. The mistake is of the tribunal. When you are quashing the DPC in this manner and saying that antedated from a prior date, much water has flown in between. What happens to the people who are selected in between? They are en bloc junior.
The English courts have taken the view. Even Supreme Court, Honorable Supreme Court has taken the view. The court should adjudge rights of the parties as on the date they first approached it. Subsequently, what all happens, what we should do?
Then the question would be that Vishnu Mishra going ahead of us is acceptable. People who have not approached the tribunal have been given a march ahead of us without us being heard at all. Now, Miss Pami's clients, they were not there before the tribunal. They have been given a bonus without being there in the tribunal, and we are made juniors without us being heard at all.
Your Lordships,
that is the mischief which the tribunal committed, not the OA applicant.
The applicant's case is based. The applicant only succeeds if the Rule 10 is interpreted the way we are interpreted. And if Rule 10 is interpreted the way we are interpreting it, then it is understood that they will always remain below us. Because your Lordships, it takes time for anything to get decided in the court.
It takes a lot of time.
What does the court do? Puts you back into the same position you would be there.
Had things been accomplished in accordance with rulings?
Yes, Your Honor. And I have placed 2 more judgments, which says, if a statute says something is to be done,
should be done that way, otherwise not.
Or not at all. That's my sum and substance of my case. Your Lordships, the DPC admits.
Number of.
Yes, 700. It did not give good reason within the meaning of Rule 10 to differ from it.
So your view is that DPC, that Rule 10 never gave discretion at all.
At all.
Once it arrives at the vacancy point, rightly or wrongly, that it should have acted upon.
There's a reason for it. Very, very important reason. I went through the other rules here. There's a difference between a direct recruitment and something which happens in promotion. Promotion, Your Lordships, though you don't have a fundamental right for promotion, but you have a right to be considered for promotion. Thing is, stagnation is not good for administrative service. So as and when vacancies arise, please kindly consider, neither for administrative, neither for satisfaction of the employer. But Your Lordships, what I found in other rules, in none of the rules, when it comes to promotion, requisition has anything to do. But in direct recruitment, requisition has a role to play. And to that extent, I'll give one rule, Your Lordships. There's a reason for it.
I've got voice rule.
So therefore, a person who's outside the service does not have an employee-employee relationship, or his rights are yet to come. But a person is already in service.
You have right to be considered for promotion.
Yes, when promotion happens, even hike in your salary happens. A lot of amplification happens. Nobody likes stagnation, neither do we like stagnation as lawyers.
And what are the tribunal directed? Tribunal said that those who are promoted, take the anticipated vacancy and consider the case of 58 persons that were left out if it would have been 750.
Their contention is, what you were the only person before the tribunal. The tribunal should have granted relief to you at the most. Why it gave relief to so many people by to our prejudice is their contention.
The implementation would call a higher
is that a consequence it happens is your answer.
Yes.
Well, that has been answered in 3 judgments of the Supreme Court. Your Lordship invariably flowed that in that or Srivastav's case and Sri Lalita case.
Lalita said those who did not come to court also should be given the relief.
Yes, in fact, I remember correctly, Your Lordship has in this court given a judgment that benefit of the judgment should be given to persons, those who have not approached the court in time also.
But the seal did not include upsetting the rights of others.
That your Lordship will see that how even one petitioner will be given unless the cadre
exercise is conducted. Wholesale exercise has to be.
I'll just read one line.
It cannot be for one single individual.
The judgment has not been implemented. So many people have come. If that interpretation is taken every year, I'll be adding people because everybody will go down. I say this, I put forward before your lordships. Whoever comes to the cadre takes a subjective to the cases pending, informed or not informed. Because your lordship, somebody will come today in the direct recruitment. He will say, no, this person wasn't there. I'm at serial number 40. I can't go to 80. So, because your lordships, litigations take time.
And in K. Ajit Babu, the status of a judgment of the tribunal has been held to be judgment in rape in service matters. I'll just read one line there. It is true that judgment given by the tribunal.
But we have been taught in the law school. Judgments in rem are rendered in only in 4 jurisdictions. One is admiralty, relating to ship, etc. Another is matrimonial, relating to marriage, divorce, etc. Insolvency, the economic state, financial status. The last one is probate jurisdiction, where will, etc., etc. Barring these 4, one is added, one I added by my judgment, where Constitutional Court declares validity of the legislation as bad. It applies not only to a person who was before the court, but to the rest of all the people. Otherwise, you would have.
Yes, absolutely correct. I'll just read one line. It is true that it may help a class of employee at the same time adversely affect another class of employee. In such circumstances, the judgment of the court or the tribunal may not strictly be judgment in personam, affecting only to the parties to the cases. There would be judgment in rape. 1997 Supreme Court.
All right, but they were saying it is not applicable to, not only applicable to party before the court, but also applicable to others, but not rem it is. The word is used that.
Yes, sir. But that is by dealing with the Central Administrative Act. Dealing with the case, madam.
That judgment?
That is 1987 Supreme Court, madam.
Consider.
1997 Supreme Court, 3277.
1997?
Supreme Court.
87, 97.
97.
97, what is that? AR, SCC?
AR 1997 Supreme
SC?
3277.
Paragraph? You could put some paragraph.
Paragraph, madam. It is not, paragraph is not given in that.
Because under section 41 to 43 of the Evidence Act, 1872, the judgments in personam and judgments in rem are considered.
Yes.
With Amirali, when Woodruff and Amirali, in their commentary on Evidence Act, they have treated it in volume 2.
Since take a case, my lord, where the tribunal considers a rule and interprets it in a particular manner.
This is in terms of section 90 of the Administrative Act. This judgment was rendered keeping in view Administration section 90.
It is as to the interpretation of the legislation or rule position. That will be judgment. We can't say judgment in rem because anyway, Apex Court used that as judgment in rem, a bit extending the idea of res judicata that. They have clarified that judgment.
Yes.
In a subsequent, I don't remember that case, but I have my notes on that. It has, Apex Court has clarified what is meant by judgment in rem in the context. It said it would be res judicata to other people also that way.
That was also considered here, madam. In that case also, they have said section 23, 22F. They have said, if we not allow madam, the agreed party to challenge the judgment, even if he was not made party, then it will be hazardous. In that context, they have said. And the other 2 judgments, madam, where madam in OFS case, dealing with Rangaya, only one paragraph may not show to also. In the Orissa Administrative Service madam, there is a condition regarding requisition to be taken as per the regulation. That was the starting point of process.
Requisition?
Requisition, they call for the names. There is a regulation. And that was taken to be the starting point of.
No, in the absence of Madam Pami's argument, yes. Rule 10 or 15,
are silent.
They are silent
yes.
about requisition. Therefore, wherever lawmaker intends that
Yes.
the reckoning point should be the requisition, he would have said,
Yes.
Madam Pami did not give those rules to us.
Yes, Your Lordship. No,
What is the administrative?
I went through where I found requisition is a concept only confined to direct recruitment. Only confined to direct.
The feeder category.
Yes, Your Lordships. This was also a feeder category for direct recruitment. Your Lordships will see here.
Commission.
So here, by an OS case, it also requires in case of promotion.
Wait. The promotion in OS.
Particular provision. Rule 6(3) of the regulation.
Rule 63
Of that 1978 regulation. That has been referred to, Madam.
which regulation by whom?
Madam, 9.6. That's government, Madam. Odisha
Odisha
Administration.
government.
Yes, Odisha Administration Service, Madam. Here, Madam, Odisha
9.6.
Finance Service has been bifurcated to OTAS Service and Odisha Finance Service.
You also file your notes.
Yes, Madam.
Everybody give us the notes. It becomes easy. Otherwise, your points may be lost in
Yes,
our.
so
My lord,
this is
my lord,
just
this last panel is
how
keeping
requisition
up
has
page 6, Madam.
direct recruitment.
Page 6, Madam. Paragraph 9.6. Recruitment process by way of selection and promotion was to be initiated by the state
Promotion.
by calling for recommendation.
Second time, third time we have got the moment it will be now implemented, if that will be implemented other than the petition.
Now, we have also got promotion.
One person, if it is brought, we have no objection. This en bloc people coming ahead of us, then obviously
That
we
is a
will
my lord,
consequences.
that is a different concept, no? 9.6 doesn't say about requisition.
No,
It
Madam.
speaks about the selection or promotion was to be initiated by the state by calling for recommendation from collect.
Yes.
Recommendation from collect.
Yes, Madam.
That's
In
it.
that they have said recommendation.
No, collect, it's not that thing.
No.
It is.
I have said, Madam, wherever it is required, state has put that. Whereas Rule 10 is silent.
Your Lordships,
that context,
your Rule 10 is silent about in
Yes.
fact happening prior to PPC.
That is,
Yes.
I'm sorry, Melon. Two people, because two people had a vote.
Mr.
The
Bharat is
other
trying to do.
Rashmi. One, so two individual applicants.
OP1 and 2. OP1 and 2. OP1 and 2.
OP1 and OP1 in the other.
But
OP1 in one case, OP1 in another case.
Increment automatically gives all of us coming with
And only one line.
Your
small. I've given one
notes you have to
note.
give.
I've given a note, but I'll.
Today's argument also you.
Yes, Your Lordship.
But only one judgment of the Supreme Court. Recent Tribunal 29th of January 2026.
I said with
Dealing with
I
USP cases.
said with Madam Megad, I didn't submit another note unnecessarily, that would be confusion. Because all my
Sub-item 5,
My lord.
that has not been adjudicated by the tribunal, my lords. We are actually supposed to be before a single judge. my lords. Sub-item 5 of this particular, all these cases. Sub-item 5 is item 14. What's WPC number 11, OSC number 1120 of 2007.
They followed the same judgment in that.
No, my lords, they have never adjudicated. Our case is different from all the cases, my lords. It came as a transfer because the tribunal was abolished. The matter was transferred to this honorable court. So it has to be heard by a single judge, my lords.
Guided by the division.
This is totally different. my lords.
Sets aside then that follows. It's all linked to
It's not linked, my lords. Our case is totally different. Our case is, my lords, we were direct recruitment.
Then it has to go before the single judge.
And he's saying he's a direct recruiter. Now, as I told you, Your Lordship.
No, I'm not a direct recruiter in that sense. Our case is different.
No, even otherwise also, because of the abolition of the tribunal, matter will go before the single judge.
22.
Post this matter
It is
before the learned single jurisdictional, before the allotting court.
112.
My lords, before, my lords,
1120
My lords.
2007.
my lords, page 94, the tribunal's order, operative portion I will place, my lords.
In view of the above, the respondent authorities are directed to convene a review DPC for consideration of the case of the applicant. If he comes within the zone of consideration in respect of the remaining 58 vacancies along with the similarly situated persons belonging to the cadre, as per their ratio, their promotion to the cadre within a period of 2. My lords, the direction is in respect of one person, and the state has challenged the order, my lords. The persons who are intervening and they have already got promotion. They have not challenged that order, my lords. Now they come to here after 5-6 years, and now everything will be disturbed, my lords.
Yeah, let's say that promotion was nothing to do with this promotion. That was a later promotion. This has nothing to do with this.
My lords, admittedly, they were promoted in 2014.
No, direction. Mishra read the direction as covering other people also.
My lords, in service, my lords, what I humbly submit, my lords, in service jurisprudence, they cannot claim relief for others. It is only individual affected parties. It is not a PIL, my lords.
Let us read the penultimate. Before that, there is a direction for general. My learned three.
No, last, however,
thing heavily for them is for this direction to be implemented. I'll place that. In view of the above, the respondent authorities are directed to convene a review DPC for consideration of the case of the applicant if he comes within the zone of consideration in respect of remaining 58 vacancies, along with other similarly situated persons belonging to Orissa Subordinate Finance Service.
no, my lords. After that, as per their ratio.
So along with those people.
My lords, next page, your lordship kindly see.
Already
However, it need not be said that
2.5 people, 2.5 times had been called. So, anyways, our names must have been there. Because the zone of country is higher.
if DPC go
3.
1 is to 3. No,
1 is to 3.
1 is to 3.
My lords, the
1 is to 3.
I saw 1 is to 3.
the direction is that if he is found suitable, he will be given appointment. My lords, kindly see.
So what he is saying
The
is
decision of the DPC
subsequent paragraph, there is only direction vis-a-vis the applicant.
applicant.
Yes.
My lords, we have challenged that. In our application, they cannot take
Even they are not affected.
They cannot take
advantage after 4-5 years. And everything is settled, my lords. Now everything will be disturbed, my lords. Promotion will be junior. And my lords, my humble submission.
Let me paste the entire paragraph. We're not keeping in view the factual backdrop of the case that they say that it has increased to 753. Even though prayer has been made to quash the proceeding of the DPC recommendation as has been made by the DPC for promotion of ACPO to Orissa's taxation and agriculture, I am of the considered view that if a review DPC is called in respect of the remaining 58 vacancies.
Then my lords, kindly finish the paragraph. Further, my lord. Further, I am reading, my lord.
The grievance of the applicants are fully meted out. In view of the above, the respondent authority has directed to continue a review DPC consideration of the case of the applicant. If he comes within the zone of consideration in respect of the remaining 58 vacancies,
That's
along
right.
with other similar situated persons belong to so as per the ratio, but their promotion to the count of so and so. What is the only case of the applicant?
My lords, I am finishing it.
There is no
Within, my lords, within a period of 2 months from the date of communication of the order, and if the decision of the DPC goes in favor of the applicant,
So it is applicant specific.
my lords, give him permission from the date the candidates who are given promoted by resolution dated 22/12/2022.
But
my lords,
your argument, if you expand it,
my
when
lords,
the order is
very specific. That is what I heard from the.
if it is party specific, they said they have no objection at all. You stand by that.
You cannot record our concession, but certainly we should not have any objection.
Only if it is party specific.
Yes.
If it is party specific, they have no objection.
My lords, what state has preferred this writ petition.
Correct.
Had the state has not
Preferred. What would have happened?
The consequence is that only 1% the applicant will.
Therefore, we are asking you,
My lord.
suppose if we dismiss the petition, we do not know what.
My lord.
Or we may allow
Simply-
we do not know. If we dismiss the petition, what would be the effect?
Effect, the applicant will be considered and
Both applicants.
my lord, if
OP1, OP2.
my lords, if they will be found suitable, they will be given.
That is two different individuals. Two different individuals.
Two read, two individuals.
And the last
There will be a
paragraph.
problem. There will be a problem. Why I'm just saying,
No, how can you take benefit when you were not before the court?
Yeah, Lordships, I'll come to it. Ultimately, it is the implementation of Rule 10. If Rule 10 is
No,
not
the
implemented,
court did not say Rule 10, etc.
No,
Court said, consider the case of OP1 in this petition, OP1 in that petition.
that keeping that 700 thing into consideration.
No, that did not say.
No, that's there, Your
No,
Lordship.
my lord, let us read little above. Keeping in view the above factual backdrop, what is about them? Keeping in view the above factual backdrop of the case, even though prayer has been made to quash the proceeding of the DPC recommendation, etc., as has been made by the DPC for promotion to SCTO to research such and such, I am of the considered view, if a review DPC is called for in respect of the remaining 58 vacancies, yes, reading the total cadre strength as 753, so he has given it. 226 minus 168 is equal to 58.
Yes.
Then also the grievances of the applicant shall be fully meted out.
What I'm trying to say is this.
One second. We want to know, you want to say that your client should be given the benefit of this order.
Your Lordship, I would say that this already gives us the.
We have two options. Either to allow the application petition or to dismiss the petition.
Right.
Order stands as it is.
Yes, Your Lordship. What I would say is this, I will humbly submit this portion which Your Lordship was just read out by the Your Lordship, the whole thing is this portion, why was it said? Because all the people who were there in the DPC were admittedly senior to us. So that need not be quashed. I mean, all the people who got in that 168 post.
Kept intact.
That's kept in because they were senior to us. We did not get it because the vacancy was shown short by 58. So the court said, you do a review DPC for 58.
No.
Yes, Your Lordship. If the review DPC
It said 1258.
My lord, among the
Case of the applicant.
for only two vacancies.
One against 58.
Your Lordship,
My
they
lord.
would have only said they drew a review DPC for two posts. Which two posts still can find.
The next the operative portion of the order.
lord.
The next portion
My lord.
made it clear.
Yes.
What would happen, Your Lordships? Suppose say I am actually senior to Mr. Mahanti's client. So if he only gets the benefit, he goes over me, even though from the date we have entered into the service, I am senior to him. That is something the law will not comprehend. Therefore, it is for the whole 50.
Now, the challenger cannot be worse off in his petition. The challenger cannot be worse off in his petition. Suppose he withdraws, Mr.
My lord, that is what I am
withdraw the petition. Where can we say, no, you don't withdraw? You can grant relief to you.
Your Lordship, he withdraw. But I would still say, Your Lordship, that the implementation of this order will require a review.
And your lordship is examining the order of the tribunal. Nothing is there.
I cannot cause greater injury to him. Best what I can do is, I can dismiss this. Can I say? Can I say more than that?
Because this one will go directed to
Your
Hon'Ble petition.
Your Lordships, if Your Lordship dismisses it, just I think we can.
No.
That Your Lordship should give.
We have, Madam Pami, we have in the law school by our professors, especially Professor Vishweshraya, Alur, and Desai, they say, where a litigant comes to you, you can say you have relief here or you have no relief here. You can't say, suppose if a person comes for some minor operation, you can't create a bigger problem to him by your surgery tactics.
I do understand that why did the tribunal vote the way?
We will not take note of that also. But we are of a view presently, subject to again reflecting on your submission. Suppose Mehra says, with all this headache, the judges are useless. Whatever curt way of telling was to extract more wisdom from you.
No, that is already.
He learned a lot.
No, you have to say this will be very
Very interactive.
happy.
Yeah, so that's how it should be. Should not bother. The Gita says, Gita means not Gita madam. The Bhagavad Gita says that only your duty is to work. That's all. Nafaleshu kadachana. Don't worry about team. Karmanne vadhikaraste nafaleshu kadachana.
You actually understand that fruit is actually the path. We never know. We might get attached to the fruit in very different way. Oh, I argued with. That can also be an attachment. It's such a very difficult path to walk.
That's true. Very process which Padajo says. The journey gives the pleasure.
Yes.
Not necessarily the destination point.
In fact, Cardozo very beautifully says on judicial process.
Company.
On judicial process. That the main problem when we sit in a courtroom is actually to get over our own biases. He writes there, and it's so stuck in me.
His growth of law is also like that.
Yes, sir.
2 books he wrote. The one is on the judicial process. Another is the growth of law. Just read that growth of law.
Growth
how
of
law
law,
goes.
I agree.
It's so beautiful. Thank you so much.
One mention, item 17. Can I pray for Monday?
Just look.